turn it over to our instructor. He is the managing attorney over in the Winter Springs, Orlando area office of K. Bender Rembaum and one of the few board certified specialists in condominium and plan development law in the state of Florida. This is Alan Schwartzseid. Alan, take it away, my man.
Thanks, Jeff. Appreciate it. So, as Jeff mentioned, I am the managing attorney for the Orlando area office of Cave and Rembaum, located in Winter Springs. We do have three other offices: Pompano, Palm Beach Gardens, and Tampa. I'm happy to put you in touch with anyone that's in your area if that's more convenient, but you're welcome to reach out to me directly. My email should be on the screen at the top right of my window throughout the entire presentation. That's going to get a little smaller once we get into the materials, but just so you're aware, as Jeff mentioned, if you're happy with your attorney, you already have counsel and you're good to go, no problem. Enjoy the show. If you don't have an attorney or you're not thrilled with the level of service that you're getting from your current attorneys, I hope you'll reach out after hearing what we have to say today. The goal of this class is to get you guys educated, and hopefully that'll also show what expertise is available to you for at least two of the attorneys that are with the firm. I believe Peter is board certified in this area of law, just like I am.
He is. And Alan, going to interrupt real quickly because this
Yeah.
question's coming up. Folks, you do not need to go into the chat or the Q&A and say, hey, am I here? Okay. The link you get after you register is tied in with your registration information. So when you click that link to join, we know it's you. You don't have to let us know. Alan, back to you, sir.
All right, thank you. So, very briefly, just a little about the firm: 25 attorneys, nine board certified in this area of law, including me and Peter, one board certified in construction. So, basically, what we do is nothing but what you need. We handle all board issues. 99.9% of our business is in representing the association. We will rarely take on, but occasionally take on an individual owner who needs that guidance or needs a little bit of help. Usually that's going to be constrained to disputes regarding elections, recalls, things like that. But we generally tend to stay on the association side, again, roughly 99% of the time. We have two mediators within the firm, so pretty much anything that you need, we've got you covered as an association. Enough of that. We're going to go ahead and share my screen with the materials for today's class. And you've already got the information regarding some of this. So we're going to move on in just a second. All right, so Peter's going to come up after me. You've got his information, my information. He'll tell you a little bit about himself, I'm sure. But let's not waste any more time. You don't need to know more about me. You need to know the information in the class. So let's get started. First topic, we're going to talk about milestone inspections and structural integrity reserves. Now, I am the beneficiary of the most boring topic for this entire class. So if you can survive the next maybe half hour, then you'll survive the rest of this class just fine. So I'm going to do my best to make this interesting. Unfortunately, in this particular topic, I make no promises, but let's get into it. Milestone inspection. So let's start with, what the heck is a milestone inspection? It's essentially going to the building, taking a look, and figuring out whether there is any structural deterioration, and specifically what's called substantial structural deterioration in your building. So it's a visible inspection, seeing, are these load-bearing elements, structural components, are they actually safe? I'm not going to go through the definitions. You can read just as well as I can. Okay, but the people that can perform this milestone inspection are an architect that's licensed in Florida, an engineer licensed in Florida, or a team of professionals with either of them acting as a registered design professional. Now, that architect or engineer that's in charge is also responsible for all of the reports, because the point of this milestone inspection is to get a report that either says every structural component of this building is safe and you're good to go, or that says, we've got some concerns here, let's make sure to do the phase two, which we'll get to in a little bit. So phase one is literally just a visual inspection of the buildings to make sure that they are structurally sound. Okay, it's not to determine whether you're complying with the building code, fire code, or any of that. It's literally to just go in and say, do we see anything that makes this building unsafe or that could create an unsafe condition in the future? Okay, so it's Is there any necessary maintenance, repairs, or replacement of structural components of the building? That's the question that needs to be answered as part of this milestone inspection report that'll be produced by the professionals that are responsible for it. Again, not checking to see whether you're up to code. It is just to make sure that the building is safe. Now, not every condo or co-op in all of Florida is required to get this milestone inspection. Doesn't mean you shouldn't necessarily do it anyway just to be safe, but it's not legally required under Florida law unless you are 3 habitable stories or more in height for each building. So this is not, is there any building in the condominium that is this height? It's not, is the entire condominium this height? It's on a building by building basis, and the determination is whether it is 3 habitable stories or more in height, determined by the Florida Building Code, and subject in whole or in part to a residential condo form of ownership. So the exclusions here, because they don't follow what this statute requires, are purely commercial buildings because they're not subject in whole or in part to a residential condo form of ownership. Single family, 2 family, 3 family, and the statute added in 2025, or 4 family dwellings with 3 or fewer habitable stories above ground. Those are all excluded, meaning they don't have to have this. Again, not a bad idea to have it anyway, but it's not required. Now we talked about in part subject to a residential condo. Mixed use and condo hotels are going to have parts that are subject to that residential condo. When we say mixed use, that's usually going to be when you've got the bottom floor of the building, like some of the buildings in Miami, Orlando, and similar areas. Some of those bottom floors are commercial, and then every floor above that is residential. Okay, so if it's more than 3 habitable stories above ground, you have to do this if you are at least mixed use, meaning there's a partial residential condo located in that building. Okay, so again, it's building by building. The association still needs to do it. The report needs to be arranged by the residential condo association and any owner of any portion of the building that's not subject to a condo. So that hotel manager, the hotel owner in a condo hotel, is going to be responsible for doing this as well at its own expense. Okay, you're each responsible for ensuring compliance with these requirements. The association pays the costs associated with the portions that it maintains under the governing documents. So if the condo hotel owner under your governing documents is responsible for maintaining the outside of the building, that's the person, that's the entity that's going to be responsible for having this report obtained. When do we need the inspection? Well, this presumes that you need it in the first place. Okay, so understand, these timelines don't matter if you're not 3 stories or greater in height, in 3 habitable stories or greater. I'm sorry, that's a change that came about just in July, so sometimes I'm still thrown off. But the initial report needs to be done by December 31st of the year when the building reaches 30 years of age. Okay, we're presuming for the first 30 years you're probably okay, or it's bad enough that you're going to see the problem. Hopefully, when the building is first created and turnover happens, you've already done your own engineering report. But beyond that, for purposes of this discussion, the age of the building is based on the first certificate of occupancy for the building. If you can't figure out when that is, sometimes like down in Miami, there was a flood in the records rooms. So you might not have that information if your building is old enough that those records were never digitized. Okay, if you can't figure it out, then you go by the date that the certificate of occupancy was issued for the first portion of that building. Whether that's an individual unit, one of the commercial units, a portion of the building, doesn't matter what it is, whatever that first CO is, that's the date you start with to calculate your 30 years. Now let's figure out when you actually have to get this done. 30 years, what does that mean? If you reach that 30 years before July 1st of 2022, meaning before this statute initially went into place, the initial milestone inspection needs to be performed by December 31st, 2024. Okay, so if you're in that time frame, you're already a year behind. So get on it now. If the building reached 30 years after July 1st, 22, but before December 31st of 2024, you were supposed to do it by December 31st, 2025. Again, You're already behind at this point. Okay, another milestone inspection needs to be performed every 10 years after the first one. So understand, as soon as you do this, the date that you have that report issued, you start calculating that 10-year timeline from that date. So it's the first one is 30 years in because we presume that you don't need it 10 years in. Hopefully, every portion of your building is already safe and still safe. But again, after that 30 years takes place, you get your first one done. 10 years after, you have to do it again. And 10 years after that, and so on and so on. So it's every 10 years afterwards. Now, I said 30 years. Initially, this statute said that if you were close enough to salt water, which there was kind of no clarity whatsoever in the statute as to what close enough actually meant, and there was a specific term, but it was unclear what it meant. You had to do this when you reach 25 years of age. You don't have to automatically do that based on location now, but your local enforcement agency can tell you that you have to do it before the 30 years if they choose to do so. So you're basically waiting for a notice from them if you're going to do this early. Now, you can, of course, choose to do it early, but understand doing it early means that you've got another 10 years when you'll have to do it again, which means you're losing 5 years from the time that you first had to do this. Okay, so you're basically saying we're going to do this early from now on. Now, after the first one, if you're waiting 10 years, you might not care, but why spend the money unless you think there might be an issue until you have to, is my perspective. The local enforcement agency has the option, you note the capitalized and italicized may extend the due date for the initial inspection if you can show that it can't be timely completed if you enter into a contract with an architect or engineer to have the milestone inspection performed and you can't reasonably have it performed before the deadline or some other circumstance needs to justify an extension. What does this mean for practical purposes? It's not just, hey, we need more time. It's, we've got a major problem trying to get this inspection done on time, and we really need your help. And then it's optional for the local enforcement agency to say yes or no. There's no must, there's no shall, there's no other item that says they need to grant this exception, even though you need it. So understand, get this done on time because there's no way of guaranteeing, even if you have a really good reason, that you're going to get a time extension. And because you can be fined for failing to do these things, they want their money. So the likelihood that you'll get that extension, especially when this is a now I think 4 year project that the legislature's had where you've known you need this for a couple of years now, the likelihood that they're going to grant any extensions going forward is increasingly low. All right. Now, this is if you prepared the report or had it prepared for you before July 1st, 2022. The local enforcement agency again may accept something that would comply with the milestone inspection reporting requirements if it was prepared before then, in lieu of having to go out and spend the money again just a year or two or a couple of years later. How long this will stay in the statute, we don't really know. There's no cutoff point where if you did it in July of 2022 and you need your milestone inspection in July of 2028, there's no guarantee that this will still be in the statute by that time. So I wouldn't just rely on that as, oh, well, we just did an inspection and it does everything it needs to do and we're probably fine. I would consider preparing yourself to have this done anyway, even if you've done it back in July of 2022, because this requirement and this name of the document didn't exist back then. And some local enforcement agencies candidly will not take the time to evaluate whether every single requirement for milestone inspections is met by your prior report. Now, if you're accepted, the deadline for the next 10-year milestone inspection is based on the date of the previously accepted inspection. So if you did this June 30th, 2022, then and it's accepted by the local enforcement agency as replacing your initial milestone inspection, you will have to do the next one by June 30th of 2032. Again, 10 years later. Okay, we need this. Now, what do we do? Well, when you determine that you need to have it done, the local enforcement agency needs to provide written notice to the association that it needs to be done. Once you get that notice, you have 14 days after receipt to notify all of the unit owners that you have to do this. We talked about the two phases. We'll get into those in detail in a minute. So phase one, as I mentioned, this is purely a visual examination of all areas of the building, whether habitable or not, including all the major structural components. And it's basically, is this building safe or is there substantial structural deterioration in one part or all parts of the building? That milestone report is going to identify what work is needed or what further inspection is required beyond just the visual. Okay, the architect is going to prepare and submit an inspection report. The phase one inspection must be completed within 180 days, meaning 6 months, after you receive written notice from local government that this needs to be done. So understand you do have a time crunch to some extent. Now, if you're already getting this done in accordance with what you were supposed to do, you're probably fine. But if the local enforcement agency says, "Hey, you got to get this done sooner than you anticipated," understand you have 6 months from the date that they tell you that. So you're going to want to look for your architect, engineer, or group that's operating under them to perform this milestone inspection as soon as possible. Once that report is submitted by email, U.S. mail, or commercial delivery to the local enforcement agency, phase one is done. They also need to send a copy to the association. Now, if there are no signs of substantial structural deterioration, you're completely done with this milestone inspection for the next 10 years. Because there are no problems, there's nothing that needs further investigation. But if there are any problems located, we move on to phase two. Now, this is the definition of substantial structural deterioration. It's not just, well, we see something we don't like. It's not, a crack this big in the paint. It's a crack in the stucco. It's a leaking window. It's, oh, well, we see this spalling in the concrete. Somehow we figured out that there's a problem because someone's balcony has problems. The railings are unsafe, things of that nature that impact the structure of the buildings themselves or the exterior structure of the buildings. Again, cracks, distortions, sagging, deflections, misalignment, signs of leakage, peeling of finishes, etc. Some of these things are not going to be enough unless it's a crack in the building. Okay, so if it's a cracking foundation, concrete, things of that nature that you can actually see, then you're going to have to take care of this. All right, moving along. Phase two can include destructive or non-destructive testing. And it's the same thing. If it's required, then within 180 days, 6 months after submitting the phase one inspection report, the person responsible for those reports needs to submit a phase two progress report to say where we're at and how long it's going to be before the phase two inspection is done. Note that that doesn't mean the phase two inspection needs to be done 6 months after phase one. Why it wouldn't be, I candidly can't tell you, but I know a lot of these people are very busy doing these specific projects, so it might take a little longer. So understand, all they are required under the law to do is provide a timeline. They might have more requirements under your contract with that vendor. So just be careful as to what you're looking at to try and tell them, oh, you needed to do this sooner. Well, your contract might not require that and the law doesn't. So there's also an inspection report after this is done, of course. Once the phase one or two is done and the report is completed, the sealed copy of the inspection report with a separate summary of the material findings and recommendations goes to the association, the owner of any portion of the building that's not subject to condo ownership, so the commercial owner or the hotel owner, and the building official of the local government with jurisdiction over your condo. Okay, so everyone that needs to know what's going on needs to know what's going on. The inspection report needs to meet certain criteria. We're not going to go through them because you're not necessarily an engineer, architect, or certain person doing a milestone inspection, but you should be looking back at this when you get your milestone inspection report to make sure that it complies. Now, I don't think it's the board's responsibility to determine whether a milestone inspection performed by a professional meets certain legal requirements. That doesn't mean I don't recommend you try and make sure anyway. All right, so once the association gets the report, and yes, I told you this was not going to be fun. We're going to get through it, I promise. Once you get the report, within 45 days after you receive it, you need to distribute a copy of the summary, not the full report, the summary, to each unit owner, regardless of whether you like what's in there or not, by U.S. mail or personal delivery to the mailing address, or email if people have consented to electronic notices. I think Peter will get into email notice later on. But if they've consented to receive notices that way, this is one of the things you can send that way. You also need to post a copy of the inspector prepared summary in a conspicuous place on the property. Usually that's going to be wherever you post notice of board and member meetings, and publish the full report and inspector prepared summary on the website if you're required to have one. Now, keep in mind, as of today, every condo in Florida, or no, yeah, 2026 was the kick-in date. Every condo in Florida that has 25 units or more is going to have that website. If you have a management company, chances are they're taking care of that for you through your portal. But if you are somehow a self-managed condo in Florida, understand that if you're 25 units or more, you're going to have to take care of this. So we'll get into website requirements later on, but I mention it now because otherwise you might not know what I'm talking about when I mention the website. These are local government enforcement mechanisms. Well, I don't think we need to go through it because it's what the local government's going to tell you anyway. If you don't do this and get the report that you're required to obtain, the officers or directors willfully and knowingly fail to have this performed, that is a breach of fiduciary duty according to Florida law, a per se breach, meaning you can be sued individually. And we'll get into directors and officers liability insurance and other fiduciary duty issues later on. The local enforcement agency can also tell you when you need to do it and prescribe penalties, meaning they can fine you a lot of money if you don't get this done on time. So they have an incentive to tell you you need to do this and to fine you if you don't do it, because unlike association fines, which we'll get into later, and we also talk about in the covenant enforcement class that our firm teaches, these ones are actually fines you have to pay versus the fines that an association levies that you really can't do anything with other than file a lawsuit and waste a whole bunch of money. But I'll jump off that soapbox temporarily. This is another requirement of the Florida Building Commission. This is things they need to do, not you, so we're going to skip it. And we get to move on to structural integrity reserve studies. So, milestone inspections are visibly checking the buildings to make sure they're safe. The structural integrity reserve study is checking the structure of the building and those structural components we mentioned earlier, and there's a whole list in the statute itself. But this is checking to see what it's going to take to make sure that each one of these items has a reserve so that you have enough money to do the necessary maintenance, repairs, and replacement of major structural components of your building when those items are expected to fail. So we'll get into what is a structural integrity reserve study, and here's the list right here. It's a study of reserve funds required for major future repairs and replacement of these items. Now, I won't go through them because there is a catch-all, this last bullet point. Any other item that has a deferred maintenance expense or replacement cost that exceeds $25,000, which is adjusted annually by the division for inflation. The division is a state entity that governs condos, or an arm of a state entity to be more accurate. Now, this $25,000 expense was upped from $10,000, which is what was in there last year. So fortunately, now you have a $25,000 minimum for items that aren't directly listed in the list above that would impact the safety, the structural soundness of these other items. So if it doesn't impact these items that are listed in this slide, and it's less than $25,000 to do the necessary maintenance, repairs, or replacement, it's not required to be reserved as part of this reserve. That doesn't mean that it's not a non-structural reserve. So when we talk about structural integrity reserve studies, we call it SIRS just because that's quicker. So if I say SIRS or structural integrity reserves, that's the same thing. If you see it written elsewhere, it's the same thing. These reserves are considered these little g items because that's the statute they're listed in, are the structural integrity reserves that every condo that is, again, we'll get into 3 habitable stories or more in Florida is required to maintain. So again, every 10 years and 3 habitable stories or higher in height. So exclusions, we talked about a couple before, same ones. You're not high enough, you're not tall enough. You have single family, 2 family, or 3 or 4, again, was a change this year. Dwellings with 3 or fewer habitable stories above ground, commercial components, or any portion of the building that's maintained by someone other than the association. If the unit owner is obligated to maintain this portion, of the building, then it doesn't go into your SERS because SERS is specifically for reserves that are maintained by the association. There's no need for the association to maintain a reserve for something that the members are responsible for fixing because the members are the ones that are obligated to pay for any repairs, maintenance, or replacement of those items. And again, commercial condos, because this is residential condos only in Florida. Um, Again, based on a visual inspection of the property, there are certain things that need to go in it. We won't go through those in detail. Now, this is a little different. Who can perform a SERS is not the same as what we discussed for a milestone inspection report. The same two initial people, primarily responsible, engineer and architect, licensed in Florida. The last one is different. So for a structural integrity reserve study, it's someone certified as a reserve specialist or professional reserve analyst by CAI or the Association of Professional Reserve Analysts. So this is a separate designation that these two groups will actually give if you pass your licensure. And you need that licensure if you are not an engineer or architect to be allowed to perform this type of service. So just be careful. And this is something you'll want to ask any vendor you're considering using for that SERS. Conflicts of interest. This is a new law that came out just this year, and it applies both to the SERS and the milestone inspections. And it is basically that if someone who is performing either of those reports and those inspections wants to be involved as an architect or engineer in the actual repair work itself, they have to disclose the intent to do so as part of their initial proposal and contract. Okay. What we were seeing was that a lot of people who had an incentive to say that there were problems and then be given the work to do and make a lot more money than they charged for the inspections were the ones doing the milestone inspections and the structural integrity reserve studies. And they were saying, I'm not saying any particular vendor, but throughout the state, this was I will call it a problem. I wouldn't call it minor or major, but it was a problem. And so the legislature, this was actually a good idea, in my opinion, put in place a requirement that you clarify, okay, I'm proposing to do this work, this milestone inspection, the structural integrity reserve study, or if it's an architect or engineer, possibly both. But I'm also looking, if there's work that we find needs to be done, to do that work as well, so that the board is aware of the reason that the vendor has to be biased in the way that they try to find problems versus seeing whether there is a problem. You see the difference. Try to find versus determining whether there is. Okay. That second one is supposed to be what this group is doing. Are there problems or not? If the answer is yes, okay, great. Work needs, well, not great, but work needs to be done, and we're going to tell you what it is. If there are no problems, there shouldn't be any reported. And okay, we didn't have any work to do as the vendor for that service. But this is a conflict of interest that the legislature is saying needs to be disclosed in advance of being able to propose the work. Now, I've had people come up to me and say, well, what if the contract was signed before this was required? Okay, my perspective is once that statute went into place more than 6 months ago now, by the way, there should have been an addendum to the contract if that vendor intended to actually be authorized to do the work under this new statute. The other alternative argument is that, okay, well, we already had a contract in place, and we'll talk about Kaufman language later, but the Florida and U.S. Constitution say that a change in the legislative process, a substantive change to rights, meaning in this instance, the right to do the work that the association needs, can't be impeded. That contract can't be impeded by a new piece of legislation. I'll explain it a little better later on. But there is an argument that anyone that already had a contract in place when that legislation went into place doesn't need to comply with this. I think that's a bad idea. I think it should be disclosed, and that frankly, no one should have a problem disclosing that this is something someone wants to do. But that's the status right now. So the deadline for this is a little different. Associations existing on or before July 1st, 2022 that are unit owner controlled. Note this is a very short time frame. Okay, so it's a 3-year time frame because the goal for this is to have your structural integrity reserve set up for the next 25 years. So this is an immediate, you got a new building, you got a building, I don't care how old it is, this needs to be done. It was supposed to be done by December 31st, 2024. Now, I actually had clients that didn't get it done in time, foolishly in some instances, but that was their prerogative, I guess, to do it wrong. But it was July of 2025 when this legislation changed to say by the end of last year now. So you still should have it done by now for those clients that didn't have it done by 2024. But they were out of compliance for 7 months, and then when the statute changed, they came back into compliance. And I hope that they've all gotten it done by now, because if not, they're out of compliance yet again with this statute. And again, the local enforcement agency can ding you pretty hard if you don't get this done. Now, if you're required to do this before December 31st of this year, 2026, you can complete it simultaneously with the milestone inspection period, but in no event can you have it done after December 31st, 2026. So this went into place basically a couple years ago, where you didn't have to get the milestone done, but you had to get the CERS done. Now this doesn't really matter. You're required to have it done by December 31st, 2026, unless you came into existence later on. If the milestone inspection is required, or an inspection was completed for similar local requirements within the past 5 years. Now note that this is a specific time frame that wasn't included in the milestone statute. But if it meets the structural integrity reserve study requirements, that can be used in place of the visual inspection portion of the CERS. So instead of the person performing the CERS having to go out or get a drone out to your buildings, they can just look at what was in the reserve study or the milestone inspection from the last couple years. Now, again, another law that came into place July 1st of this past year. If the association completes a milestone inspection or an inspection for similar local requirement, the association can delay the CERS for no more than 2 consecutive budget years. This will require a member vote, by the way, immediately following the milestone inspection, in order to allow the association to focus the financial resources on completing the repairs and maintenance recommendations of the milestone inspection. In plain English, what this means is, if you have a bunch of construction that's required to make your building safe, you don't need to put away money that is for the future when you need to have that money that the owners can't afford to pay for both. You need to have that money now to do the necessary repairs. So the statute says you're allowed to do that, but only for up to 2 consecutive budget years. Okay, we have our CERS. Now what do we do? Well, we talked about what you need to do after you get the milestone inspection. It's pretty much the same thing here. Within 45 days after receiving the CERS, the association needs to give a copy to each owner or deliver a notice that says the completed study is available for inspection and copying. The copy of the study or notice needs to be sent by U.S. mail or personal delivery to the owner's address, or by email if the owner has consented to receiving notice electronically. You also need to provide the division online on its website with a statement indicating that it was done and that the association provided it or made it available to the owners in accordance with that requirement that I just mentioned. Okay, now the division has created a form that gets posted on their website. They include a section to actually upload the CERS. You are not required to do that. Okay, there's a lot of information that they ask for that is optional, but they don't clarify that it's optional on their website. So you might want to run it by counsel as to what you're really required to provide, unless, excuse me, you want to be a lot more forthcoming with information than you're required to be. I am politically silent when it comes to these webinars, but I am a libertarian when it comes to leave me alone and I'll leave you alone unless it hurts somebody. So my perspective is leave this alone. If you don't need to give information to the government, maybe it's a good idea not to do so. Now, the structural integrity reserve studies, the study itself, the report, needs to be kept for at least 15 years after it's completed. And if you need to have a website, it also needs to be posted there. This one is new as of July 1st. An officer or director needs to sign an affidavit acknowledging receipt of the completed CERS. Now, this is not your manager. Note that it only in the statute and this slide says an officer or director. So usually the manager can sign any affidavit that says we received this, we sent out a notice. This one is very clear that it needs to be an officer or director, not your manager. All right. If you don't do it, again, this is a statutory per se breach of fiduciary duty. So bottom line, follow your requirements, do the SIRS, move on with your life. Now, if you're required to obtain the SIRS, the reserves need to be maintained for the SIRS items, those little g items that we mentioned earlier, pursuant to the declaration. Okay, so how do we decide what we're responsible for maintaining, meaning what we're responsible for including in the SIRS? You look at the declaration, that's it. The reserve amount for those items must be based on the findings and recommendations of the most recent SIRS. For practical purposes, what does this mean? If you don't like what's in the report, get a new one. You can't just ignore it. You'd be violating Florida law to do so. You need to fully fund those reserves. We'll get into what that means from a practical standpoint later. But you can't just ignore because you disagree or because you got some other statement, like an estimate of what the work would cost. You need to go back and get that SIRS adjusted because otherwise, even though you've got documentation to show it's wrong, you're not in compliance with Florida law and you can get dinged for it. You don't like getting dinged. Um, you can, however, adjust these reserves annually to take into account inflation adjustments and changes in estimates or extensions of the useful life caused by deferred maintenance. But again, you're going to want your contract for this SIRS to say that this person's going to provide updates for the next, let's say, 5 years, as long as, you usually it'll be at a reduced rate as compared to starting from scratch. And it'll just be an update to that component rather than starting over completely. But you want to make sure that's in the contract because if it's not, then you might have to pay for a new SIRS every time you do that work. Don't do that. Very expensive, big mistake. Okay. The exemption to needing to have that reserve included for each one of these structural components of your building. If you can't figure out what estimated useful life will be for this component, not readily ascertainable, you do not need to reserve for it. Doesn't mean you shouldn't, it means you don't have to. Or if the estimated useful life is more than 25 years, you don't have to start putting away something that's rated for 40 years on day one. Doesn't mean you shouldn't. And once you hit the mark where it's going to be 25 years now, so in year 15, you will have to start putting that money away. But if at the time you get that SIRS done, that is rated for 25 years or longer, you won't have to put money away for it. But you need to put away the deferred maintenance expense recommended by the SIRS for those items. So even though you can't calculate it, if your SIRS includes those components of your building and it says, the roof, the building enclosure, blah 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 blah, this item, and it says for this item, the useful life is 30 years. We recommend putting away $1,000 a year instead of the 30, 40, 50 that you would have to put aside in the event that it was a 15-year item. You still need to put that $1,000 away every year unless your SIRS is updated to reflect a $0 balance for that line item for that year. Waiving and reducing for the SIRS reserves for budgets that are adopted on or after December 31st, 2024. So every budget from presumably 2025 and this year and going forward. You may not waive, you may not reduce SIRS reserves, period. So if it is one of those structural components, you must fund the full amount that your SIRS reserve report says you need to fund every single year. Okay, you can't determine that you're not going to fund them fully. Now, we talk about alternative funding methods. I haven't seen that in practice. It's in the bottom bullet right here. I haven't seen that actually happen in practice the entire time that this has all been going on using that alternative funding method. So we're not going to go through it in detail. Now, understand that is for the SIRS reserves. The first bullet here, the non-SIRS reserves, is what used to be for everything. You can waive or reduce that specific reserve component, that line item, by majority vote of the total voting interest of the association. So it used to be, I believe, that it was a majority of a quorum of members showing up at a meeting. This is specifically a majority of all voting interests to waive or reduce non-SIRS reserves. I'm going to reiterate again. You cannot waive or reduce or use for any other purpose your SIRS reserves. They are structural, they are mandatory, and they are There's a term that includes an F-bomb that I won't use, but you cannot mess with them, is what I'm gonna say. For a
And
budget
certainly you mean free food, right? The very
yes.
popular four-letter F word, free food.
Yeah, we'll get into the free food later, but
Okay.
we'll pretend that's what I meant. Thanks. For a budget that's adopted on or before December 31st, 2028, the statute was amended just this past year to say that if the association's done the milestone inspection pursuant within the previous 2 calendar years, the board, with a vote of a majority of all members, again, all members, majority of all members, can temporarily pause for 2 consecutive annual budgets the reserve contributions. If you pause those reserve contributions to fund milestone repairs, you need to have a search performed before initiating the funding to recommend an updated funding plan, meaning you're not required to fund those reserves for another 2 years, but you will need to get a new SERS after that milestone inspection, the work that's listed in the milestone inspection is done. For funding the SERS, the reserves can be funded by regular assessments. Now, special assessments, lines of credit, or loans was recently added. So these are new options for how you fund them. It used to be that you just shoved it in the maintenance assessments and you moved on with your day. But because they can be so absurdly expensive, I've seen some communities have to triple their assessments just to pay for I won't call it a catch up payment because that's inaccurate, but the increase in what you've never reserved for before. And some of these components are going to be up in 5 years. Now, all of a sudden, you're required to reserve for all of them. A special assessment line of credit or loan now requires approval of a majority vote of the total voting interests of the association. So you need to get a member vote. Now, the wrinkle here, and this is the first time I'll mention it, but it applies to a lot of what we're going to discuss today and that Peter will discuss today. The legislature doesn't necessarily ask or listen to attorneys that are well versed in this area of law before passing these laws. What they didn't think of and have not corrected, even though it's been pointed out for the last few years, or at least the last year in this instance, is that your declaration may say you can pass a special assessment or get a loan without a member vote. So, why do we need to get a member vote according to the statute? Is my question. And the answer is the legislature doesn't seem to have thought that one through, but it is what's required as of now. So understand, you can this special assessment, you might want to talk to your attorney about whether there's case law out there that says if you're required to do it and you need a special assessment to do it, can we work around what's in the statute? Okay, run that by your attorney. I'm not giving you advice on it right now because there is some risk, but you might be able to do that with a board only vote. The lines of credit and loans don't have that case law benefit where, if it's certain things that need to be done, you not only have the right, but the obligation to levy that special assessment or shove it into the budget. Okay, so run that by your attorney if you're debating between the special assessment, the line of credit, or the loan. If you're just doing it as part of your assessments, you just got to shove it in there. Now, a developer-controlled association where the non-developer unit owners have been controlled for less than a year, or one controlled by one or more bulk assignees or bulk buyers. That's where you've turned over, but a single entity has bought a bunch of units back up. This doesn't apply. So you don't need that unit owner vote. But because all it says is this doesn't apply, the question is whether you're even authorized to use these alternative methods of funding funding your SERS. So again, kind of a mess, but we're trying to get it fixed in this year's legislation, which is just starting to come up. Now, the line of credit or loan that you do get needs to fund whatever wasn't funded before, and the funds need to be available immediately upon request. So it can't be, oh, we are filling out an application, and if we tell them we need the money, we'll get it in 30 days. It needs to be, we need the money, it gets transferred to our account as soon as we ask for it, because you need to be able to fund those repairs as soon as they're needed. Again, using reserves for a different purpose is the exact same vote as we mentioned earlier for using, reducing or waiving reserves. So you can't do it for SERS. If you're going to do it for non-SERS reserves, that needs to be a majority of all the voting interests that vote in favor of using those funds for a different purpose. Pooling. So the statute was changed this year to clarify you can use a pooled reserve. We thought that was the case, but we had to kind of be a little bit cautious. But pooling is where instead of having just a bunch of line items in your budget or in your SIRS report, you have an actual reserve where you have, we won't call it a slush fund because that's not what it is, but you have a pool of funds that are available to use for any one of these line items versus, for the roof, we're putting aside X amount of dollars. Okay, you know what you need for each one of these when the work needs to be done, but you're just putting the money in so that the next component that's expected to fail, you'll have the money for, and so on with every next component that's expected to fail. Whereas in a straight lined method, you're talking about, well, we're putting aside this 30,000 for the roof and this 50,000 for the driveway or the roadways, etc., for repaving, and these are way underestimated. I'm just throwing numbers out there as an example. But your line item, putting that money away on a let's figure out what we need every year basis versus in a pooled method, you're putting away what you need for the next item that's expected to fail. Now, the reserve funding indicated in the proposed annual budget needs to be enough to ensure that available funds meet or exceed what you expect to need for all of these reserve components based on the reserve funding plan or schedule of the most recent SIRS. So again, you're not just haphazardly deciding here's how we're going to do it. It's based on the SIRS, and the person that prepares that SIRS is going to have to know, are you using a pooled or a straight line method of accounting for these reserves? Now, the vote of the membership is not required for the board to change from pooling to straight line or straight line to pooled methods of accounting. Now, that doesn't necessarily mean that you won't need that vote to move the funds from one to the other. Okay, so remember what we said. You can't move the funds in straight line unless you're using it for that purpose, and you can't even vote to use it for another purpose. So you may have issues that you'll need to run by your attorney as to how that money gets moved, reallocated, or just used up as needed for those straight line reserves. Moving forward, local government intervention. If a local building official determines that the entire condo building is uninhabitable, now specifically due to a natural emergency, not just because you didn't maintain it, the board can pause the reserve contribution or reduce reserves until the local building official determines that the building is habitable again. Any reserve account funds held by the association may be expended pursuant to the board's determination to make the building and structures habitable again. Once the local building official decides the building is habitable, the association needs to immediately resume contributing funds to its reserves. And keep in mind, not only will you have not funded during that period, but you'll be underfunded because you'll have used some of this money. So after this is all done, as we mentioned before, you'll need a new SIRS or at least an update to your SIRS for the components that you worked on and the funds that you didn't put aside. Okay, what else? Moving on. Developer is required to provide their own SIRS. Now, the developer has certain obligations shortly after turnover. This is now one of them. I wouldn't necessarily rely on what the developer is telling you as to what you'll actually need. You might want to get your own report performed, but this is at least going to outline what the developer thinks should have been set aside, potentially by the developer, but in reality now by the association. So when I mentioned you need to start doing this immediately, that's really what I meant. The developer even is supposed to be doing this. Unit owner disclosures to prospective purchasers. This is done by the unit owner, so I'm not going to go into it. But just understand when you are selling a unit in a condo, there are new requirements. Hopefully your realtor knows about these. And yes, we're skipping a couple slides, and the reason for that is we're on slide 47 out of 180, and it's 1252. Now, keep in mind, this is the most dense material, so I can breeze through the next few sections so that we catch up and keep in line with the timeline we're supposed to maintain. Disputes regarding the milestone inspections and SIRS effective July 1st, 2027. So right now, technically, there is not a specific manner in which these disputes are supposed to be handled. But effective July 1st, 2027, they'll be handled the same way as any covenant enforcement violation. It is a dispute as used in section 718.1255, which is what defines disputes and dispute resolution. before a lawsuit is filed. So what we're talking about here is if you don't get the milestone inspection or a CERS done within the time you're required to do it, the failure to fund reserves or the failure to make or provide necessary maintenance or repairs of the condo property recommended by a milestone inspection or CERS, this is going to be considered a dispute that's going to require mandatory pre-suit mediation. And if it's not resolved by pre-suit mediation, which we talk about separately, we've now got a separate mediation class that I'm sure we'll be scheduling to teach in the near future again. But if that is not, excuse me, I'm going to take a sip of water for the first time in an hour. If that doesn't resolve the issue altogether, that's going to result in litigation if the person complaining decides to file that lawsuit. Now, understand, because this is not considered a dispute under that statute now until July 1st, 2027, then you need to look at the statute for a breach of fiduciary duty, which, as I mentioned earlier, failing to do any of these things is considered a per se breach of fiduciary duty, meaning that you're not necessarily suing the association. It's a lawsuit against the individual members of the board. Now, you may sue the association as well, but there's nothing clear that says how you're supposed to handle this right now. I don't really know why the legislature chose to wait until July 1st, 2027, but that's what's been in the statute since I think 2023. So as of now, we're fully expecting this will kick in July 1st. I expect mediators to be busier. Hopefully, this will be handled in the way that they're not busier because people are doing what they're supposed to do, but that's what we're anticipating going forward, is that there will be more pre-suit mediations regarding these issues rather than just going straight to litigation. Now, pre-suit mediation is something I fully support. It's the reason I got certified as a mediator, because I would say between 70 and 80% of the time, those mediations result in a settlement that a judge never has to see, and you never have to take the risk as a result of a judge never having to see it, that you're going to be responsible for attorney's fees and costs in addition to getting the issue resolved. All right, I told you we'd move on. Now we get to do that. So we're going to move on to elections and official records and record keeping, including websites. So elections are step one. When do you need an election? When there's a vacancy on the board caused by the expiration of a term. What does that mean for practical purposes? Either every year, most likely, or if you've got staggered terms in your governing documents, usually in the bylaws, yeah, maybe it's every 2, 3 years if everyone carried over. But most likely, you're not going to have 2-year terms for everyone. So if even one person on your board is subject to re-election in this year, you're going to have that every year, that election, or at least prepare for it. We'll get into that in a minute. Now, a vacancy on the board that's caused before the expiration of a term, except by a recall, is generally filled by one of these two things. Either you can hold an election, and I'll tell you in just a minute why that's a stupid idea from my perspective, because it requires a whole procedure that, frankly, if you can just appoint someone, you don't need to go through, you don't need to spend the money on, which is the more important part, and you don't need to deal with the potential disputes that arise because of an election challenge if you screw up the procedure here. Rather than risk all of that, which could be tens of thousands of dollars dealing with an election challenge, maybe just go ahead and have the board vote, and a majority of the remaining directors, even if there's only one remaining director, get to go ahead and appoint someone to take that role on when this person either resigned or was disqualified. We'll talk about why you might be disqualified later. Okay. But the bottom line is, my perspective is you should always appoint someone. Setting up another election is just a waste of time and money and creates more risk than is necessary, in my opinion. So moving on, what does this election actually look at from a timeline perspective? The first step that everyone is required to take in a condo election is that not less than 60 days before the election, you send out your first notice. It's basically, hey, we're having an election. Here's the time, date, and location. If you want to submit your notice or your intent to be a candidate, you need to do that. So the next deadline is exactly for that. If you want to be a candidate, then no later than 40 days before the election, you need to submit an actual written notice of the intent to be a candidate. And at that time, you have to actually be eligible to be a candidate. We'll talk about that in a minute. If you don't submit your notice of intent within those 40 or before that 40-day timeline elapses, You are not eligible and you cannot be listed on the ballot. You are not a director. Even if you would have gotten the most votes of anyone and everyone in the community loves you, you are not eligible, including if you're currently a director and subject to reelection. Now, if the candidate provides it, the association needs to provide a fact information sheet. This is a standard 8.5 by 11 sheet, including information that the candidate wants the members, all of the other members, to see. The board has zero discretion in trying to change what's on there, redact it for information that they think is inappropriate. It just needs to be provided to the members. Now, if it's not submitted at least 35 days before the election, so that gives you 5 days after you submit your notice of intent, if you don't submit it on time, that is not going to be provided to the members. So if you provide it not less than 35 days before, it goes out with the final notice of the meeting. That notice is sent somewhere between 14 days before, so you give enough meeting notice for a member meeting, which is a minimum 14 days. No more than 34 days before the annual meeting because it needs to include all of those candidate information sheets. Okay. That's going to go out together with the written notice of the meeting, which is your second notice, as well as your balloting process documents. That's going to be your ballot itself. It's going to be an inner envelope that puts the ballot inside with no markings whatsoever. That's what maintains anonymity of who's voting and how. And then you're going to have an outer envelope that entire package goes into that does have the contact information, meaning the unit number, a signature from the owner, etc. That way, you can identify who has already voted, whether this person is eligible to vote for various reasons, etc. So again, you've got 60-day first notice, 40 days candidacy, 35 days when you need to submit that information sheet, and 14 to 34 days you need to send your final notice of the election meeting. Now, the number of directors that will be elected, unless the governing documents say otherwise, the board is 5 members. Now, if you've got 5 or fewer units, the board is at least 3 members because we're not going to require every single person to serve on the board. If the articles or bylaws permit you to serve longer than 1 year, the terms of all directors expire at the annual meeting unless the condo is a timeshare or non-residential. The staggered term hasn't expired, which I mentioned earlier, until a later annual meeting, or all directors' terms would otherwise expire, but there are no candidates. Okay, so term limits is also going to be an issue starting this year because a director can't serve more than 8 consecutive years unless approved by 2/3 of all the votes cast in the election, or there are not enough other eligible candidates to fill the vacancies on the board. Now, only board service that occurs on or after this statute came into place, which was July 1st, 2018, are used in calculating this term limit. What does that mean for practical purposes? You can serve until June 30th, 2026, this year. Now, what's not clear under the current version of the statute is whether it says you can't serve more than 8 consecutive years. Does that mean that if you're midterm when this happens, you have to stop serving and drop off the board on June 30th? Nothing in the statute is clear on this point. So a workaround that exists now, and I know the legislature is working on a fix for a clarification and a fix for this loophole, but I will point out, technically, if you resign and are added back on the board, you didn't serve more than 8 consecutive years. Now, the question is, based on the wording of the statute, you're still in 8 consecutive years, even if you come back on, a month later. So this is one that you'll want to run by your attorney if you've been on the board for this long, whether technically you're off automatically as of June 30th, 2026. My opinion is you're probably not. It's also something that you don't necessarily have to deal with until someone raises the issue, but be aware that it's a risk and it's something that you might have to contend with at some point this year. Now, co-owners in a residential condo of more than 10 units can't serve as directors at the same time unless they own more than 1 unit or there aren't enough eligible candidates. Election by acclamation is basically there weren't enough people that submitted their names for candidacy compared to the number of vacancies. So if you have 6 director slots open this year that are up for reelection, and only 5 candidates put their names in, those 5 people are on the board automatically. You don't need to hold an election. If you had 6 people, same deal, no need for an election. Once you hit 7 or more, that's when you need to have an election because you need to select between people. Okay, this acclamation is we don't have anything to select. There aren't enough people that you need to actually vote. It's an automatic yes as long as everyone that's listed is eligible. So there's no quorum requirement during a condo election, but at least 20% of the eligible voters need to cast a ballot in order to have a valid election. They're decided by plurality, meaning the candidates with the most votes get elected. Now, every record pertaining to this election, your ballots, your sign-in sheets, voting proxies, and all of your electronic voting information from your vendor is all kept for 1 year after each election. Okay, that is an official record of the association. We'll get into the official records in a minute. But that is something that you are obligated to maintain. Now, if someone wants to challenge the election process, meaning they're not saying, I don't like who's on the board, that's a recall. Okay, we'll get into that later on. But if they're challenging the actual procedures used, the timelines when notices were sent, the address was wrong, things like that, they only have 60 days after the election result is reported, which might or might not be during the election meeting, to actually raise that challenge. If they don't file for arbitration between the election result being announced and 60 days later, they've waived that right. They can't file any election challenge thereafter. Now, a candidate is an eligible person. So I use those interchangeably. An eligible candidate, a candidate, because if they're not eligible, they're not a candidate. Now, that's someone who has timely submitted the written notice of intent. Anyone that wants to be on the board needs to be eligible as of the date when they needed to submit, like I said earlier, so not later than 40 days before the annual meeting where the elections take place. Otherwise, if you're not eligible on that 40-day timeline, sorry, but you can't be listed on the ballot. Even if every single person on the board wants you to be, even if every member wants you to be listed, it's not an option. The statute says you're not allowed to be listed. Person who's delinquent in payment of any assessment due to the association as of the deadline to submit the intent is not eligible. Now, note what it doesn't say. Anyone who hasn't paid fines is not listed there. It's got to be the assessment that's delinquent. Keep in mind also, the fact that it's past due doesn't mean it's delinquent. You need to look at what your declaration and your bylaws say about when something is considered delinquent, because there may be an automatic grace period that says you're not delinquent until day 10, 15, 20, 30. So just be careful not to presume that just because someone's not current, they're delinquent. There's no definition of delinquent in the statute, so you need to look at your governing documents to verify what that means for your particular community. A person who's been suspended or removed by the division under the Condo Act. The division, again, is that enforcement arm of the state for condos and co-ops and a couple other types of community. Not eligible to be a candidate. Suspended or removed, not just there's a claim that there was something done wrong, just to be clear. Someone who's been convicted of a felony or something that would have been a felony if it occurred here and has not had their civil rights restored, meaning they've been out of prison for at least 5 years on that date, is not eligible to serve. Now, the good news is if you find out about this later on, because a lot of people will ask, well, does that mean we have to do a criminal background check for everyone that wants to be on the board? That's an option. It's an expense and it's not necessary. And whether you have the right to charge the members who want to be on the board for you to perform that background check needs to be in the governing documents, in my opinion. So there's no reason that you need to do that. The validity of anything that person was involved in as a director before you found out is not subject to being undone. So it's kind of a no harm, no foul situation. If you find out after the fact that this person just got out of prison 3 years ago and they moved in immediately and you've known him for 3 years, great guy, never done anything remotely bad in the entire community, served their time, but it was only 3 years ago, they haven't hit that 5-year mark, they're off the board. Anything they did before is fine, but this is an automatic. If a criminal charge is pending against an officer or director, this is another reason that you might not be eligible to serve. Okay, this is forgery of ballots, theft or embezzlement of association funds, or obstruction of justice. Any of those. Now, this is a charge pending. not just John down the road said he stole a bunch of money. Okay, this is an actual criminal indictment or information. Those are the legal terms. They may not be appointed or elected to the board or as an officer of any association and can't have access to any association records except pursuant to court order. So if you know that this is going on with one of your members or one of your directors, first of all, if it's a director, they're off the board. But if it's one of your members, that is one of the exceptions to when you'll actually have to comply with a records inspection request. We'll talk about that when we get to official records. Voting is by secret ballot in a condo, period. No proxy, limited or general, can be used in elections because we've got this balloting process that I mentioned earlier. An election ballot's cast using the inner and outer envelopes that I talked about. The exterior of the outer envelope needs to indicate the name of the voter, the unit that they're voting on, and a signature. This is how we verify, like I mentioned earlier, who's voting, whether they're entitled to vote, whether they submitted multiple votes for the same unit, which would then cancel out and be discarded, and you write discarded on there. Now, some attorneys will tell you put discarded and then put the reason. My opinion is, why would you put that on there if you have another reason that your attorney finds that that vote should have been discarded and it's not the one you wrote down? You now lose the ability potentially to use it for that purpose in addressing an election challenge. Now, I'm not suggesting that you should be duplicitous. I am not at all suggesting that you should disenfranchise members and say you're not going to count their votes, but there are certain votes that you can't count because they're submitted wrong. So just be careful with the way that you mark those. Each inner envelope can only contain one ballot. That's another one. If there are two ballots in an inner envelope, those are all discarded because you can't tell which is the right one. Whether they voted the same doesn't make a difference. It's not a, well, I voted both ballots exactly the same, so you should at least count one. No, that's not the way the law works. That is an argument I've had to deal with before. Separate inner envelopes are required. Now, if someone has more than one vote that they're entitled to use, they can put all of their envelopes in the same outer envelope, all the inner envelopes in the same outer. The problem's going to be trying to track what other units that person owns to justify more than one vote. So my recommendation to the unit owners that are here, and my recommendation to the board telling the unit owners what to do, is to warn them in advance that we really need a separate inner and outer envelope and ballot for every single unit that is voting. Even if you submit 20 different envelopes, that's fine. I hate the waste of paper. That's why I recommend electronic voting, among other reasons that we'll get to in a minute. But make sure that you are using all three pieces of what you're supposed to do to make sure that your vote actually counts. Now, the other thing that'll invalidate a vote is if you had 6 people that were eligible, 7 or let's say 10 that were on the ballot, and you vote for 7. The board doesn't get to unilaterally cross one of those off because they don't like that person or for any other reason. So that ballot will be invalidated in exchange for voting for more people than are eligible to serve, or voting for more positions than are open. Okay, that's another reason to invalidate an election ballot. Let's see, we already went through some of this. Once the association receives a ballot, you cannot change it. Once it's in, you're done. So you can't say, oh, I want to change my ballot because I like John better now that he gave me a bunch of stuff. It doesn't work that way. That's called a kickback. It's election fraud, and it's not allowed anyway. But even if you just decide to change your mind, sorry, but you shouldn't have submitted. Now, electronic voting vendors may allow you to do that, but from a physical paper standpoint, absolutely not allowed. You can't authorize someone else to vote on your behalf. Ballots improperly cast are invalid. If you violate that provision, the association can actually fine the owner. And a unit owner who needs help in casting the ballot is a different story. If it's due to a disability, that is a, what's it called? A reasonable accommodation is the name for it. We have a separate fair housing class that we teach. That one's free as well. We won't have time to get into it in detail, but I think Peter has those slides to cover later on. But this is a necessary accommodation to allow the person the same enjoyment of their unit. How someone enjoys voting, I don't know, but that's the term from a legal perspective that we're supposed to use. So the enjoyment of all benefits of the unit, including the right to vote, if someone doesn't have the ability to do it because of blindness, disability, or inability to read or write, they can obtain assistance in doing the balloting. Now, I talked about verifying the outer envelopes. This is how we're going to make sure that each ballot that gets cast in an inner envelope is something that should actually be counted, making sure that the people that are on your roster are actually the ones that are voting. This can be done before the election by noticing a separate meeting of an impartial committee consisting of members that aren't current directors, officers, or candidates, or any of their spouses. This is also an open meeting. It's noticed like a board meeting. It's held the same day as the election. Okay. The signature and unit ID of the outer envelope needs to be checked against the list of qualified voters. If someone is not qualified to vote, we'll get into the reasons someone might not be allowed to vote in a minute. But if they're not qualified to vote, then you put discarded on there, just like you would with any of the other problems with a vote, and you put it to the side. Any outer envelope that's not signed by the eligible voter is also disregarded, discarded, whatever. And any ballots contained in that inner envelope or outer envelope, actually, the outer ones are the ones that contain markings. So the outer envelope is going to not be counted, it's discarded. Anyone who engages in a fraudulent voting activity related to an election is a first-degree misdemeanor now. That is, I think, a change from this past year, July. Using threats, bribery, or intimidation related to voting or casting a ballot. That includes offering bribes, offering threats, or offering intimidation. Forgery of a ballot envelope itself or a voting certificate is also punishable as a third-degree felony. So keep in mind, we're talking about crimes to decide who's on the board. Maybe just let it play out how it should, or how the vote would play out, instead of risking, criminal prosecution related to an election in a condo. It can't be that important. I understand this is your home. This is the most important investment you've probably ever made or will make. However, it's not worth jail time to try and get John down the hall elected. That's all I'll say. Now, electronic voting, I'm not going to go through it in detail, but essentially you need to use a vendor that knows what they're doing if you're going to use electronic voting. This is, rather than submitting the ballots in the manner that I just described, you actually go through either an app or a website and click through in order to vote. I recommend that every condo in Florida do this, not because I'm promoting any particular vendor, but because the alternative is really, really stupid and dangerous. And we'll get into what that is in just a minute. Now, keep in mind the most important things for electronic voting. You need a board resolution to adopt it. It can't just be you hire the vendor, they take care of it. You need to actually adopt that resolution. That can now be done within 48 hours before the meeting versus where it used to be 14 days before. So that's the good news. You will need to make sure that the vendor is qualified. You need to provide a way to confirm at least 14 days before the voting deadline that the electronic device that the owner is going to use can actually use the voting system. You need to authenticate the person's identity, which is why I think this is a much better option, and a bunch of other things that the vendor is going to be responsible for doing. If you authorize online voting, the first notice needs to disclose the procedure and deadline and consent to electronic voting. What does that mean from a practical standpoint? You should probably get your electronic voting vendor in line and adopt the board resolution before you send out that first 60-day notice of the election meeting. If the board authorizes online voting, the board needs to honor a unit owner's request to vote electronically at all subsequent elections, unless they opt out. What does that mean from a practical standpoint? At every election going forward, if you used electronic voting once, every member who opted in, because keep in mind, this is not just you offer it and everyone has to use it. Every individual unit needs to opt in to do it that way. But at every election after you've opted in or that member has opted in, they can tell you they want to vote this way. And even if you didn't intend to pay that vendor, you're going to have to do it. Now, again, I think it's the right move anyway, based on other legislation that changed this past year that we'll get to in a minute, but understand that you'll have to do it. A vote of the unit owners can't be taken on anything other than the issues specifically identified in the electronic vote when a quorum is established based on unit owners voting electronically. So you can't just add issues when people are voting in advance via electronic medium that they don't have the right to vote on these new issues. So you just can't tack them on to the meeting. They need to be on the agenda. You need to give notice, and you need to give every member the opportunity to vote on each issue. That doesn't mean you have to allow every member, you don't have to wait until every member votes for the decision to be made. Okay, so if people choose not to show up, choose not to vote electronically, that's on them. But everyone needs to have the opportunity at that meeting to vote on every single issue that you're going to address. Now, the other one is if you choose not to do electronic voting, you might not have a choice anyway. If at least 25% of the voting interest of a condo petition the board to adopt a resolution, meaning 25% of the members are saying we want electronic voting, the board needs to hold a meeting within 21 days after receiving that petition to adopt the resolution. The board needs to receive it within 180 days after the date of the last scheduled annual meeting, meaning there's actually an election coming up and there's a reason to bother doing this. Okay. Let's see. Yep, we went through that. Okay. Electronic ballots. So this is the one that I said makes absolutely no sense to me. If you don't use electronic voting and you're in a condo, you have only one other option that never existed before, and it's to allow every member that doesn't opt into electronic voting, or I'm sorry, every member, since you're not using electronic voting, to email you their ballot. You need to actually separately send out a ballot that's distinct from the one that you're using for mailed ballots or hand-delivered ballots. And it needs to be submitted by email at a separate email address that the association creates just for this purpose. That also needs to be listed in the final second notice of the annual meeting. That email address needs to be included, the ballot needs to be included, and the members get to vote by basically sending you an email and filling out a piece of paper that they don't even have to actually sign other than writing the person's name. It can come from any email address whatsoever. So John down the road can vote for 50 different people. And yes, that is election fraud and it will throw off your election, but there's nothing in the statute that protects against that. The statute gives discretion to DVPR, the division, to create rules regulating this stuff. But this kicked in July. It's now January, and the DVPR has not actually adopted any rules, regulations, or anything else regarding these rules, regarding these emailed notices. The owner needs to send the ballot back to that email address before the annual meeting or the election starts, and that's the only thing that they're required to do in order to vote. There's a rebuttable presumption that the association reviewed all the folders associated with that email address to receive those ballots if a board member, officer, or agent, that can include a manager, provides a sworn affidavit attesting that they reviewed. So meaning that you're counting all the ballots that you got, presumably you're checking your spam filter as well. You're wasting a bunch of time that your vendor could be using. You might be spending more money paying your manager to spend time reviewing this stuff. And then you have to sign an affidavit verifying that you did everything you could to make sure that you enfranchised as many voters as humanly possible. Now, the only thing that needs to be on here is this capitalized statement that you're waiving anonymity. So people are giving up their right to vote anonymously because it's sent directly to that email address that every member of the board and every manager probably has access to. It needs a space for the unit owner to type their unit number, to type their first and last name, which is their signature, just typed, and this statement in capital letters. So that's the form that needs to be included as the ballot. Now, the problem is, again, it would not be difficult for someone to send 10,000 of these and shut down the entire email address or fill it up. There's nothing that precludes an owner from sending a bunch of gigantic attachments to that email address and filling the inbox so that certain people can't vote or that you can't read that email address, the inbox. There's nothing that says someone can't send a whole bunch of ballots for the sake of invalidating the election. And yes, that would be technically a crime. So what? They could send 5,000 of their own ballot and it's not technically election fraud. So now you're just out of luck. The attachments, you're just out of luck. And it goes way beyond that, but this is a terrible idea. So the bottom line is, unless and until this is properly regulated to require you to only accept emails at this email address from people that have registered and you can verify that it's their email address, I highly recommend against using this and highly recommend going with an electronic voting vendor so that you actually have some protection for the association. The officers. So now we're shifting out of the election. Now we're shifting into the next meeting that's usually held in conjunction with the election, which is your organizational meeting. Now, I didn't get into directors, officers, members, but let's go through that real quick now. The members are just the unit owners in your condo. So when I say member or unit owner, that has the same meaning. The owners, the unit owners, the members, all the same. So if you own a unit in a condo, you're a member of that condo. Every declaration of condominium I've ever read says that the owners are the unit owners, they are the members. Then you've got your directors. That's the board. Those are the people that the members generally will elect unless someone comes off and the members of the board, the directors, actually appoint someone else. But those are the people that the members generally get to decide who is on, just like your elected officials when it comes to your Florida and federal governments. The officers are people with specific roles within the community that are determined by the board. So the members of the community don't get to decide who's the president. The board votes on who the president is. Now, the president is usually going to be the mouthpiece of the association. They sign most of the contracts. You know what the president does, or you wouldn't be here. The vice president doesn't really have any specific responsibilities, but if the president's unavailable, they take over that role temporarily. Your treasurer is going to be the one responsible for most of the financial aspects of the association, maintaining accounts, maintaining the ledgers for each of the owners and each of the units, maintaining the financial reports and making sure that those get done. All of that is actually going to be passed to your manager for the most part if you are hiring a management firm or an individual CAM. And then finally, your secretary is the one that's responsible for the official records, the website, making sure that things get mailed out and mailed to the right place, signing the affidavits that have to do with mailing and things of that nature. But again, generally speaking, your manager is going to be the one that takes on that role if you've got a manager. So getting back to the officers, unless the bylaws say otherwise, the board needs to have a president, secretary, and treasurer who do what's customarily done by an officer of a corporation. Now, keep in mind, I didn't mention it before, but you are running a business if you are on the board of a condo in Florida. Whether you want to be or not, you're volunteer. I get you're not being paid for it, but you are running a business. And what that means is partially that, or the reason for that, more accurately stated, is that you are running either a for-profit or not-for-profit corporation, which is the association itself. Okay, the association is not necessarily the buildings. That's the condominium. The association is the corporation that you work for as a volunteer. So that corporation is also subject not only to Chapter 718, which is the Florida statutes governing condos, but also 617 if you're a not-for-profit, which most are, or a for-profit, you're under 607. So your attorney should be aware that there are not just the 718 statutes that they need to be looking at, but also 617. Now, in the event of a conflict, I think Peter will mention later, 718 is going to control the condo-specific statute controls, and that makes sense. But be aware that when it comes to this first bullet point, what is customarily performed by officers, that's outlined in Chapter 617. Now, unless the bylaws say otherwise, the board may appoint other officers and grant them duties that the board deems appropriate, meaning you can have a vice treasurer. You can have two treasurers. Doesn't matter. Unless the bylaws say you need to be an actual member or a member of the board, you don't need to be. Okay? There's nothing that says you have to be a member. Unless otherwise provided in the bylaws, there is no compensation, and the officers serve at the pleasure of the board. So this last one, there's no prohibition against changing officers midstream. If you get to the point where the president has been overbearing and won't let anyone do anything, won't let anyone speak, is going to units, knocking on doors saying, you're in violation, you need to do this without running it by the board, they're kind of running rogue. There's nothing that says you can't remove that person and have them have zero officer role whatsoever, or put them in one of the other roles like vice president where they don't have any power or the appearance of power. Okay, you can vote at any board meeting when that is on the agenda. It doesn't have to be just the organizational meeting. That can be done at any time throughout the year. Again, generally, officers are selected by the board, and directors can't vote by proxy or secret ballot at board meetings, except that secret ballots can be used to elect officers. So keep in mind, we'll get into, I think Peter's going to cover later. Every meeting of the board needs to be open to the members unless it's closed for certain purposes. That's going to be attorney-client privileged meetings or discussing employees of the association. Any other vote needs to be taken in the open. You can discuss issues by email, but you can't vote by email. You can't vote by proxy or in some other secret manner. The only exception is in electing the officers. Now, disqualifications from service, we mentioned earlier, but going through in a little more detail, if you knowingly solicit, offer to accept, or accept a kickback, that's a third-degree felony. Kickback was now defined. Oh, I'm sorry, is a third-degree felony, is subject to civil penalties and must be removed from office with a vacancy declared. This isn't a suspension. This is a you are off the board. Okay, if you accept a kickback, you're gone. The board gets to fill that spot with whoever they want or have an election, which again, I don't recommend. Kickback means anything that there's value to where you didn't pay for it for your own benefit or that of your family from someone providing or proposing to provide goods or services to the association. So if you're in the middle of a hurricane, I'm sorry, let me give a different example because I don't want to be specific. Um, Here's one that I haven't seen come up in practice, but I know that it happens in the state. Um, you're getting the building exteriors painted. And you say, well, I actually need the interior of my unit painted as well. So, I know that you're offering to do a bunch of work for the community. I might be more inclined to sign if you're able to do mine either for free or, at a decent discount. And I'm not looking for anything for free, really. I'm just trying to help you out and have you help me. No, that's a kickback. That's a no-no. Don't do it, period. Another thing that'll take people off the board is charged. Again, I mentioned earlier, criminal charges, information or indictment. Not just John down the hall said, hey, this guy did some crimes. Doesn't really work that way. It needs to be specific types of crimes in order to pull you off the board. Anything outlined in section 718, 112, 2Q of the Florida statutes regarding election, fraud, theft or embezzlement of association funds or obstruction of justice, which is basically hiding the ball, is removed from office. If the charges are resolved without a finding of guilt, that person is reinstated for the remainder of the term. Now, if that term is already over, we discussed, you might have a 1 year term, 2, 3. If that term is over, sorry, but you don't automatically get put on while someone else was already elected. Doesn't work that way. A director or officer that's more than 90 days delinquent in payment of any monetary obligation. Now, remember, before we mentioned if it's just before the election, it's assessments alone. If you are 90 or more days delinquent in any monetary obligation, fines included, rekey charges included. I don't care what the charge is. If you're 90 days delinquent or more, or I'm sorry, you're more than 90 days delinquent in paying any monetary obligation to the association, you're treated as abandoning your seat on the board. You are off. End of story. Game over. Have a nice day. And again, that is not one where you can get reinstated. You can pay the full amount, and the board has the option of reinstating you once the full debt is paid. That doesn't mean they have the obligation to add you back onto the board just because you paid your debt. A director who willfully, unknowingly, or intentionally violates the official records inspection requirements that we'll talk about soon commits a second-degree misdemeanor and must be removed from office. Anyone who knowingly or intentionally defaces or destroys accounting records to be maintained when they are required, or knowingly or intentionally fails to create or maintain accounting records that need to be maintained with the intent of causing harm to the association or one or more members, commits a first-degree misdemeanor and is personally subject to a civil penalty and must be removed from office with a vacancy declared. Now, we talk about with the intent of causing harm to the association. I don't see how you can do this without the intent to cause harm to the association, because not having those records or defacing or destroying them means that if any individual member requests to inspect those records, then you will be subject to damages when you're inevitably unable to produce the records you're supposed to have. So I don't see any way if someone does these things that it wasn't intent to cause harm to the association. Moving along, a person who willfully and knowingly refuses to release or otherwise produce association records with intent to avoid or escape detection. So this is the hiding the ball, or to assist someone else with avoiding or escaping detection of a crime, commits a third-degree felony and must be removed from office and a vacancy declared. Now, this I think is a little bit silly, but there's a workaround that I'll get to after I go through it. If you use a debit card issued in the name of the association or billed directly to the association, again, these are the two possibilities: name of the association or billed directly to the association. For anything that's not a lawful obligation to the association, that is now theft. You're removed from office and a vacancy declared. And lawful obligations are anything that hasn't been, or lawful obligation is something that must have been approved, pre-approved by the board, and reflected in meeting minutes or the written budget. Meaning not only did they approve it at the meeting, but you waited until the next meeting for the meeting minutes to be approved before spending the money. Or it's already in the written budget directly that you have the authority that this is going to be spent. Now, if the board finds that someone has violated these conflict of interest requirements, these are separate requirements that we'll get into. Officer or director is removed from office, creating a vacancy. A director who fails to timely file a written certification and educational certificate, which you'll get after this class, is suspended from service on the board until they comply. Now, this is different from everything I've mentioned up to now because it's just a suspension. I don't want to minimize it, but it's not a complete vacancy. So it is a vacancy until you get that certificate to your secretary and in the official records. Now, the secretary can't block you just because they don't like you and say, well, I'm not going to put it in the official records. That's their obligation. But until you submit the certificate from a class like this, you are off the board. If your term isn't over yet, you come back on as soon as you submit it and it gets in the official records. Now, this debit card thing, the theft is considered a level of theft in the amount of what you spent. So if you spent $100, it may be petty theft. If you spent 10 grand to make sure that the association had enough materials to do XYZ, that I don't know what is grand theft. I'm not a criminal attorney, but be careful. Now, I told you I'd tell you the workaround. That's to just use a credit card instead of a debit card that's in the association name, or pay it yourself and get reimbursed by the association, which isn't covered by this statute. But again, be careful. I would not even have a debit card that's in the name of the association or that the association pays directly. I would make sure it's a credit card or just get reimbursed because there's no statute that specifies. Now, the reimbursement still should be what the statute says is a lawful obligation of the association and approved by the board. Okay, so it's not just, oh, well, if we use a reimbursement, I can steal a bunch of money. Sorry, unfortunately, it doesn't work that way. But you need to be careful about how you do this. Moving on to condo association websites, I mentioned that it was 150 or more units. Now, if you have 25 or more units, you need to have this website and comply with all of the requirements we're about to go through. Anyone with less than 25 units is still not required to have a website. I think it's a good idea anyway. And if you're working with a qualified management firm, chances are their management portal is going to serve this purpose instead of you having to have a separate website. Now, it needs to be independent or a web portal wholly owned and operated by the association, or a website provided by a third-party provider, including a manager, which the association owns, leases, rents, or otherwise obtains the right to operate a web page, subpage, web portal, which is what you're using with a management firm, or a collection of these things dedicated to the association's activities where notices, records, and documents can be posted. So again, if you have a management contract, chances are your manager is offering this service. It may be at a separate charge. It may be at no additional charge. It may be, a $10 a month fee to make sure that all this is up to date. Whatever it may be, just make sure it's covered in the contract, because otherwise you're going to have a separate website that you design and create yourself or through a third party that creates it for you. And that can get expensive. The website also needs to be accessible through the internet, needs to contain a subpage, web portal, or other protected electronic location that's inaccessible to everyone else. Okay, so you want to have a way of protecting information that not everyone in the world is entitled to have, such as the ledgers of each unit and things of that nature. Okay, and we'll get into what goes on that website in a little bit. Now, when an owner requests it, the association needs to provide that unit owner with a username and password and access to the protected sections of the website that contain any notices, records, or documents that need to be electronically provided. Again, we'll get into what those are shortly. And we'll get into it right now, in fact. Here's a list of everything that needs to go on this website. And you'll see when we go through the official records, it's a very similar list, but there are distinctions. So if you put everything that is an official record on the website, you won't need to worry about whether you're complying or not. You're complying. If you don't put everything up, you need to have at least the governing documents, the articles of incorporation, which are generally included in the governing documents, all your rules, a list, not a copy necessarily, but a list of all executory contracts or documents that the association's a party to, not drafts, signed documents, or the unit owners have an obligation and responsibility, and after bidding for the relative materials, equipment, or services, has closed a list of the bids received. Again, not the bids themselves, but a list. And you can include summaries of bids for materials, equipment, or services exceeding $500. That needs to be maintained on the website or application for a year. In lieu of summaries, you can just attach all of the complete bids on your website. So you have a list of the bids and either a summary of all of the last ones over the last year or copies of the bids themselves. Rather than have to put together that summary, my suggestion, just upload the bids themselves. It'll take up more space, but it'll take up less time. The annual budget and any proposed budget. So I said not drafts of contracts, but definitely drafts of budgets to be considered at the annual meeting, financial reports, and any proposed financial reports. The certification of each director, that certificate that we mentioned earlier. All contracts or transactions between the association and any director, officer, corporation, basically anything that is a conflict of interest, any contract or document regarding conflict of interests, so not just the contracts, but also any related information that shows why there's a conflict and why it was approved anyway. Notice of any board meeting, the agenda, and other document required for the meeting must be posted no later than the date required for the notice. So in a member meeting, that's generally going to be 14 days in advance. Now keep in mind, you only need to upload, this is the second bullet. I was going through it anyway, but here it is. The association needs to upload the meeting notice and agenda for any member meeting at least 14 days in advance, possibly longer if your governing documents say so. But either way, the actual documents that you're voting on, let's say it's a contract the members get to vote on for some reason because the expense is going to be absurd and your governing documents require a member vote for X amount of dollars or more, that document needs to be uploaded to the portal, your website, no later than 7 days before that meeting. Again, this is a member meeting. The requirements for a board meeting are different. We'll get into those in a minute. You need to upload the most recent CEUs and all inspection reports related to the structural or life safety inspection of the condo property, copies of all building permits issued for ongoing or planned construction, copy of all affidavits required by Chapter 718, regardless of the subject matter, the approved minutes of all board meetings held over the last 12 months, and that's a list of everything that needs to go on. So again, it's not everything, but if you have everything uploaded, it'll make your life easier. And when we get to records inspections, I'll tell you why. Now, failure to post any of these documents doesn't in and of itself invalidate anything the board has done. So when someone says you didn't upload the bid, so you weren't allowed to vote on that contract, no, these are separate issues. You have a problem that we didn't upload the bid or the summary that includes it, fine. But that doesn't invalidate the vote itself. The association needs to designate on the website someone with a street or email address to receive requests for estoppel certificates. So it's basically when you're going to sell or mortgage your unit, who needs to be contacted so that they can point out all the things that need to be done in order to bring your unit to a current status, whether that's, assessments that need to be paid, violations that need to be cured, etc. The The association also needs to ensure that the information and records that aren't accessible to the unit owners aren't posted on the website. Meaning, if the members don't have access to it, they don't get it in a different way. And the general public certainly shouldn't have access to it if even the members of the community aren't supposed to have it. If protected or information restricted, excuse me, let me rephrase that. If protected information or restricted information is included in documents that are required to be posted, you can redact them. Matter of fact, not only you can, you must redact them before posting them. And if you're complying with this posting requirement, there's no liability unless the disclosure was intentional, made with knowing or intentional disregard of the protected or restricted nature of the information. For example, if you have documentation, it's completely innocuous, but it contains someone's social security number. You don't catch it because it was just an email that was completely unrelated to any personal information. Technically, you're not responsible. Now, unless there was knowing or intentional disregard of the protected and restricted nature of the information. If you saw that information and chose not to restrict it or chose not to redact it, then you might be responsible for some damages, if any arise. If you choose, I think I know of maybe one or two communities in the entire state that are using an app instead of a website. Most of them are using an app in conjunction with a website if they have one, but you can use either or. Now, that app will need to meet all requirements of what a website would need to have. And you might have some older members that are saying, I don't have a smartphone. I don't know how to access the app. So you need to provide this information to me in a separate way, which is yet another reason that I suggest you use both a website and an app so that at least maybe they're tech savvy enough to get onto your website, even if they can't access the app. And we move on from websites to official records. Now, yes, I'm blitzing through, and I promised you that I would try and keep it light, but I also mentioned I have some of the most boring information in this entire presentation, so I apologize if I'm not my usual excitable self. But we're going to get through the information. Maybe the Q&A will be a little bit more fun for everyone. Now, official records are basically the documents that the association needs to maintain that are pertinent to the operation of the community so that everyone has access to them and can see what was done, what wasn't done, how it was done, etc. Because a lot of decisions are just made by the board. And Peter, I think, will get into this later, but most of the decisions, in fact, that are made by the association are made by elected officials and not directly by the members. So we want to have a record of what happened, how it happened, where it is, and what went on. Now, I'm not going to read through this list or the entire next list, and the reason is we've got item 22 in bold here. All written records, whether specifically included in the statute or not, that relate to the operation of the association are the official records. So as long as it's in writing and pertains to association operations, you need to maintain it, period. Now, how long you need to maintain it is determined by the statutes as well. It's also determined by a statutorily mandated policy that if you haven't adopted already, you need to adopt now. And now that you're hearing this, you're aware of it as well. If your attorney doesn't know that this is a requirement, I suggest you reach out to another attorney. But you need to have a records retention policy that says how long you're going to keep these records, when you're going to destroy or delete them, how they're going to be maintained, where they're going to be maintained, who's going to maintain them, etc. Now, a couple specific items that got added to the statute this year that really weren't necessary, in my opinion, other than the specific timelines. The approved minutes of all board meetings over the preceding 12 months, those were already official records. Hey, Peter, we got Peter joining us. We'll be done in just a few minutes. The video recording or a hyperlink to the video recording for all meetings of the association, the board, or any committee for the last 12 months that were conducted by video conference. And what does that mean for practical purposes? If you don't have the meeting via Zoom or you conduct it in a hybrid format and you say, well, this is an in-person meeting, but we're going to provide a Zoom option, maybe you don't have to maintain that record. Okay, that's maybe a workaround. I say maybe. Now, the other thing to keep in mind, you don't need to keep that official record. Doesn't have to be the recording that's uploaded to your website, maintained as accessible directly. You can keep just a list of hyperlinks, and as long as those hyperlinks work, That's good enough for each one of these items. And then the affidavits that are required by Chapter 718 are now also official records, which again, someone wanted their name on a bill. That wasn't necessary from my perspective because it was already a written record that pertained to the operation of the association that needed to be maintained. But now it's official. Um, we have minimum retention periods. Generally speaking, official records are maintained for 7 years, but we've got this whole list of governing documents and developer records that now need to be maintained permanently. The CEUs and all inspection reports are kept for 15 years. All bids are kept for 1 year. Election records are kept for 1 year. So this is one of the reasons you want to have, even though it's statutorily required anyway, I had been recommending that people have a records retention policy even before the statute says so, so that you have something to rely back on that isn't just the statute that says how long you're going to maintain all of these items. They need to be maintained in an organized manner that facilitates inspection of the records by a unit owner. This is an obnoxious requirement that just kicked in, I think, 2024, because everyone kept all these records in boxes. And the way you would do your inspection back in the day was here's 40 boxes, good luck finding what you're looking for. And the legislature now says, yeah, sorry, but that's not good enough anymore. You actually have to put things together in a way that can be looked at. That's yet another reason, in my opinion, to just store all of your official records on your website and make them all accessible. Another that we'll get into in a minute is when people are submitting requests to do a records inspection, your response can be, that's all on the website. Have a nice day. Let us know if you have any problems accessing it. And you're done with the records inspection as long as you send that response. So yet another reason to make sure everything is uploaded to your website. Now, if the official records are lost, destroyed, or otherwise unavailable, the obligation to maintain them includes a good faith obligation to obtain and recover them as reasonably possible. This was just added in, I think, in 2024 or 25 as well. It wasn't required before. Now you need to seek out records that you don't have if they ever existed, if they were lost, destroyed, or otherwise unavailable. I mentioned inspection and copying. So after you receive a written request, you've got 10 business days to produce this. All of the inspection and copies of the records. You don't need to actually just say, here are physical copies. You don't need to pay the cost of making those copies. The owner is responsible. If you have an inspection policy, which is number 2 out of the 8 that I think everyone should have, is a records inspection policy. Now, the inspection needs to be offered within 45 miles of the condominium or within the county. Again, you can just say, hey, this is all on the website. Go look there. If you have any problems, let me know. But again, you need to provide that inspection within 10 business days. If you provide a date, time, and location for the inspection, let's say you're doing it in person, that is enough from my perspective to satisfy your obligations. You don't need to keep providing 10 different dates and times that the owner can come in. It's your inspection will take place on this date at this time at this location. And if you can't make it, I don't know what to tell you. Now, I would put all that in your inspection policy. Renters do have the right to inspect and copy only the governing documents, the rules, and the inspection reports, not everything. So if your inspection request came from a tenant, keep in mind that limitation. In the association, like I said, you can either have the records available on condo property at any time, offer the availability so you can come in and look at it either in person or on a computer or however, or basically say, yeah, you can go ahead and look online. They're all on our website. Leave us alone. The right to inspect includes the right to make copies at a reasonable expense of the member. Now, when we say reasonable expense, that's up to $0.25 per page, and the first 25 pages are free according to Florida law. You need to allow the member or the authorized representative to use a portable device, meaning they can scan for free to make electronic copies. The association needs to maintain what the statute doesn't define is an adequate number of copies of the declaration, articles, bylaws, and amendments, the current rules, the Q&A sheet, and the year-end financials, so that they're available to unit owners and prospective purchasers whenever they want, and charge the actual cost for preparing and furnishing those documents. Now, my perspective is if you have one copy, 99.9% of the time, that's going to be an adequate number of copies. Just keep it saved on a computer, keep one printed copy so that people can pay for it. And my suggestion is put right on the front, here's what each one of these documents will cost you if you want a copy. If people aren't willing to pay for it, they don't get it. Moving on, we talked about some of this. You do need to have a checklist of all records made available and all records which were not available. Our perspective is you can just make the checklist as a bunch of categories, not each individual document. So that can be very generic, and you basically are copying and pasting from the statutes that say what is versus what is not subject to this type of inspection. It also needs to identify any official records not produced. It needs to be maintained for 7 years. And the delivery of that checklist pursuant to the requirement creates a rebuttable presumption that you did everything you were obligated to do as part of that inspection. I mentioned rules, so we won't go through that, but understand the fact that someone made a request is all that's required as long as they're entitled to get and inspect and copy the official records. They don't have to show any proper purpose or any reason that they want to inspect the records. Okay, so you can adopt rules regarding time, frequency, location, notice, and manner of the records inspection. You can limit it to once a month. You can say you can only have 8 hours per month and split it up however you want, but you can't say you're not allowed to do this unless you tell us why you want to do it. So again, that's your records inspection policy that I think everyone should have. There's a whole list of records that are not accessible to the members. I won't go through them in detail because frankly, I want to get to some Q&A, and it's a statutory list that you can just read through if you want. So we're going to skip this. Yeah, attorney-client privilege is very important, so we'll cover that. Any record that's protected by this attorney-client privilege and anything protected by work product privilege is not disclosed to the members. Now, attorney-client privilege doesn't lie with the attorney. It lies with the association, the corporation itself. So no individual director, your law firm, your manager, none of those people can decide to disclose that information. It has to be a decision that is made by the board as a whole through a board vote. So it's not just, well, John thinks that he should be disclosing this information. John needs to find out from the attorney whether it's privileged or not. And if it is, that information should not be produced, period, to anyone outside of the board, management, or counsel. Now, if you don't provide access in time, you give the members what's up to a $500 gift plus fees and costs, because any failure to provide the records within 10 business days after receipt of the written request creates a rebuttable presumption. I mean, you can fight it, but you might not have the right to do so or the ability to do so, that the association was intentional in failing to produce these records. And if you failed to produce these records in a willful, knowingly, or intentional manner, that is a second-degree misdemeanor now. It used to be twice in a year. Now it's at all. So bottom line, produce the records. Okay, whatever's in there is going to come out eventually anyway in discovery. You're not hiding the ball. You're not hiding anything. You're not avoiding capture, so to speak. Just produce the records unless they are truly confidential based on the Florida statutes. Let's see. So defacing and destroying, we talked about. I think we went through all this. Anyone that leaves the board or a committee needs to relinquish all official records and property of the association within 5 days. Calendar days, not business days, after they come off of the board or the committee. If they fail, knowingly and willfully fail to relinquish that documentation, they're subject to civil penalties imposed by the division. Now, Peter's going to cover topic 3, so I'm going to go ahead and get through as much Q&A as I can in about, we'll say 10 minutes, and then I don't want to cut off Peter's time, so I'm going to cut off the Q&A, at least for my portion at that point. Jeff, I see a ton of chat, but I'm going to just skip all that and go straight to the Q&A.
Yeah, don't worry about the chat. The chat is mostly non-attorney questions.
Okay, good. Okay, so I'm going to go just through each one, and I'll mark that I answered live if I did.
Okay.
When does the board have to vote as opposed to a president signing? This is Michael asking, signing a $30,000 pool repair. I didn't even see the proposals, and they said they signed something. I feel this is a conflict. Well, let me clarify a couple points here. There's nothing in the statute that says because something is a certain dollar figure, the members get to vote or the members get to see what's going on. That decision should be made in an open board meeting. There are ways around that Peter might mention later. But generally speaking, yes, the members absolutely have the right to see whatever bids, or at least the bid summaries that should be on the website if you're 25 units or more. You can do a records inspection request if you feel that the membership is not seeing the information they should see, and ask to inspect records pertaining to this pool repair that you're talking about. But there's nothing statutorily that says because it was a certain dollar figure, the members get to vote or to be involved in the decision beyond attending the meeting, speaking at the meeting where the board made its decision, etc. You say you didn't see the proposals. It might have been that there was a posted notice of the meeting. You didn't see it, so you didn't attend. I'm not suggesting that your board definitely did this right, but the things that you've mentioned don't necessarily mean they did it wrong. There's no conflict of interest in existence in general unless there is the interest of one of the directors or their spouses or their family members and the company that did the pool repair. So I wish I could give you a better answer, but unfortunately, you're giving some details that don't necessarily lead to problematic behavior. Or maybe that's fortunate. John Kowalski, are there any requirements for single-story condos? And I presume this pertains to the milestone inspections and CEUs that we talked about earlier. The answer is not at all, although you might have local requirements that are not statutory, that are codified in your municipal code for your particular city, county, whatever. So just be careful of that. Like Miami-Dade has a requirement. I think Palm Beach has a requirement. The city of Orlando has a requirement that you recertify your property every 30, 40 years. So there's no statutory requirement for single story condos. That doesn't mean you're not going to be subject to local requirements. Lek asks, for the past 7 years, we had a 5-member board. Month before the election, the board voted to reduce the board to 3 members, minimum required by the bylaws, just to keep other candidates from joining. What to do about this discriminatory practice? Well, if it's discrimination, that might be a separate fair housing issue that you can discuss with the Fair Housing Authority. However, it sounds like it's just something you don't like and you're upset with rather than true discrimination. It may be that the board was trying to minimize the people that are on. You'd have to look at your bylaws to see what it says about how to determine the exact number of people on the board. If it authorizes the board to make the decision between 3 and however many, just because you had 5 for the last 7 years doesn't mean that it was wrong to change the number now. Now, if it says it can be changed with a member vote, that was done wrong, and that's something you might pursue. But generally speaking, I'm not seeing anything automatically wrong, kind of like what I mentioned earlier with another person that asked a question. Cindy asks, when the board adopts a new policy, can the old policy be archived on the website on a folder that's not visible to the entire community? I don't see a reason why you wouldn't be able to do that, but keep in mind it says rules and amendments. So my perspective is you're taking some risk by not including the former policy with everything. What you would do is an amended and restated policy or something of that nature, and maybe you have a completely separate document that contains all the old documents. When I'm setting up a document book for a client, that's the way I set it up as well, where book 1 is current documents that are operative right now. Book 2 is here's all the old stuff that we're not using anymore because it's been amended and restated. So that might be one way to do it. Again, you can do it the way you're asking. I just think there might be some risk based on the way the statute is worded in doing it that way. Why were elevators left off the list? Scott asks. You need to ask a legislator why they left it off the list. It's not a structural component. It is a safety component. And that's my guess, the reason why they left it off. I think they were nailing us with enough crap at one time that to add elevators to that list might have made it even more onerous, that you now don't have a choice but to reserve money for those repairs, replacement, maintenance, etc. But I can't really speak to the mindset of a legislator that's forcing us to do all this in the first place, because I completely disagree with requiring CEUs in the first place, although I think milestone inspections are a crucial function. So moving on to Cindy, the old policy can be requested. Oh, this was in line with what was asked before. Already addressed it, so we'll move on. Lek, what's the requirement for an association to have a website? We went through this in detail, but if you have 25 units or more in your condo, you need to have a website or at least a management portal that functions the same as the statute requires that website to function. Dominic asks, what are these affidavits found? Where are the affidavits found when needed to comply with DBPR? The affidavits are all of the ones listed in the Florida statutes for your mailing of your notices, the structural integrity reserves, the milestone inspection reports being delivered, etc. If you're asking for specific forms, your attorney can prepare those for you if you need it. It's just a basic affidavit that says this document was mailed or this was done on this date. It's not anything super complicated, and usually it'll include the list of people that that document was sent to as well.
Alan, before you get to the last couple, reminding everybody, please, 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 the chat is reserved for technical questions only, and also where we're going to place the evaluation link. So you could ask me non-class related questions in the chat. Use the Q&A module for anything course related. Back to you, Alan.
All right, we're going to get through three or four more. I'm going to try and be quick. What's the rule or law regarding pooling of reserve funding? Can reserves be pooled to handle large expenditures? Short answer is yes. But again, you need to be careful about how and when you move the funds from a straight line to a pool. Not an issue anymore regarding shifting the method of accounting. The other thing to keep in mind that I didn't mention earlier, yes, you can use pooling for your SERS and non-SERS reserves. Anything that you choose to put in a reserve, you can also put in that pool, but it needs to be something that's properly established with a member vote as an actual reserve. Valerie asks, how do SERS reserves requirements apply to condos with only 2 habitable stories? They don't apply at all. That's not 3 stories or greater habitable, so you don't need it at all. Anissa asks, we had 2 board members up for re-election. No candidates ran. 1 board member submitted a resignation but agreed to stay on after the other board member fell ill before the meeting. The board member dies. We aren't notified until 12/12, which is after the annual election. The other 3 board members must vote the 1 board member back on. Correct. Yes, you would still be reappointing this one director, leaving 1 vacancy, and you could appoint for that vacancy or hold an election to fill it. Can you review the process for completing a resolution, including approval and legal filing requirements? I don't know what kind of resolution you're talking about. So unfortunately, Gerald, I can't really answer that question. You're welcome to email me outside of this, and I'll be happy to see if I can kind of get through it. But we're at 2:05, so I am going to shut down the Q&A on my end for now because I want to give Peter as much time as he needs to also answer the questions that you guys have. I appreciate it. Oh, no, Peter's not going to answer any questions. All right, my mistake. I should have known better. I know the guy well enough by now. But I want to give Peter the time to expand on whatever issues he wants, even if he doesn't get to the Q&A. I'm going to give him, most of his 2 hours. I appreciate everyone being here. If you need to reach me, my email address is right on the screen. It's as@kbrlegal.com. I thank my partner, Jeff Rembaum, for not making it A. Schwartzseid again. And Jeff, as always, thank you for your help. Peter, really appreciate you stepping in and helping out today. Not a great situation, but we genuinely appreciate it. And I know you'll do a great job. Otherwise, I would have told Jeff not to use you. So, Peter, I turn it over to you. Again, thank you, everyone. Have a great day. If you need to reach me, feel free. And now I get to shut up and log off.
Thank you, Alan.
Take
Thank you.
care, Alan. And we're going to now introduce Peter Mollengarden, who is, again, I mentioned earlier, there are very few board certified specialists in this in condo and plan development law in the state of Florida. We have yet another one here. So Peter Mollengarden is out of our Palm Beach Gardens office, and I'm going to now turn it over to Peter to get started. Peter, how you doing, man?
Good, Jeff. Thank you. Appreciate that. Okay. I am doing, well, I'm going to say part 2, but it's really topics 3 and 4. And following Alan is difficult, but I will do the best I can. As Jeff said, I'm a board certified condominium plan unit development specialist. Been doing this kind of law for 42 years, more or less. And I've represented developers, associations, mostly associations for the bulk of my career. Okay, enough about me, not that exciting. Topics 3 and 4. First thing we're talking about is transfer fees and estoppel certificates. So transfer fee, that's the fee that a condo association can charge with respect to a unit when it is sold or leased or otherwise conveyed. And the crucial things to know here is that you cannot charge any type of fee in connection with the sale, mortgage, lease, or other transfer of a unit unless you have the authority to do so pursuant to your declaration, articles, or bylaws that In other words, they have to expressly say that you have the right to approve the transfer and that you have a right to charge a fee for that transfer. Now, currently, the maximum fee that you can charge is $150 per applicant, except a husband and a wife or a parent and a dependent child, they are considered to be one applicant. And on this, you also have to be careful that if your documents limit you to less than that $150, then that's all that you can charge. But you can't charge more. The other thing I want to mention here quickly is, I do review a lot of documents, rules, regulations, things like that. And oftentimes I see associations where they'll have a transfer fee, they'll have an application fee, they'll have a door fee, different types of fees. And I guess the bottom line is no, you can't basically try to increase this by calling the fees by different names. There are some cases where associations have gotten into trouble for basically charging too much with respect to the sale or transfer of a unit where they've charged more fees than they're allowed. Now, also, if you have a lease or a sublease and it's a renewal with the same tenant or subtenant, sublessee, you cannot charge a fee. So if the same lease is being renewed, same tenant, no additional fee. What you can charge, though, again, if your documents so authorize, your declaration of the bylaws, you can charge a security deposit with respect to the lease of a unit. That's to protect against damage to the common elements and to the association property. Although it is limited, okay, not to exceed 1 month's rent with respect to that particular lease. It must be kept in an escrow account maintained by the association. Again, it's to protect against damage to the common elements or the association property. And payment of interest on that security deposit, claims against the deposit, refunds, all that kind of stuff, or any dispute related to it is handled pursuant to Part 2 of Chapter 83, Florida statutes. What is Part 2, Chapter 83? That is basically the Florida Residential Landlord Tenant Act. So just as a residential landlord tenant, this deposit is treated the same way as a security deposit for any other lease, residential lease. Estoppel certificates. This is crucially important when a unit is being sold or otherwise conveyed. Estoppel basically means detrimental reliance, okay? That a party is relying on another party, and that's what an estoppel is, and we'll talk about that right now. So within 10 business days, it's not calendar days, but within 10 business days of receiving a written request, either electronically or otherwise, in writing, for an estoppel certificate from an owner, a mortgagee, or either of their designees, you have to issue the estoppel certificate. You must designate on your website, and again, you have to have a website now if you have 25 or more units. You must designate on your website a person or entity with a street or email address for receipt of the estoppel certificate requests. They must be completed by a board member, an authorized agent, or authorized representative of the association, including any authorized agent, representative, or employee of the association's management company. As far as issuing them, they must be issued either by hand delivery, regular mail, or email, so no facsimile, on the date of issuance of the certificate. Estoppel certificates must be signed by an officer or authorized agent of the association. What goes on the certificate? All right, the date it's being issued, the name of the owner of the unit. Again, so if the unit is owned by Joe Smith and that unit's being conveyed to Betty Sue, Joe Smith, the current owner, is the name on the certificate. The property designation, i.e. the unit number and the address, parking or garage space number as reflected on the books of the association or in the books and records if there's one been assigned or more than one been assigned to this unit. You need the attorney's name and contact information if this unit's account is in delinquency or is in collections and has been turned over to the attorney for collections. You have to include the fee for preparation and the delivery of the estoppel. We'll talk about the fee in a second. And the name of the requesting party. Now, this is the real meat here as far as the assessment information, because the purpose of the estoppel basically is to find out, among other things, but the main purpose is this unit delinquent and are there any special assessments due within a certain period of time? So what goes on there? the amount of the regular periodic assessment, i.e. monthly or quarterly, levied against the unit, and the frequency of the assessment. So again, how much per quarter, how much per month. Date that regular periodic assessment has been paid through. So if it's been paid through a year ago, because it's a year delinquent, that's what you indicate. If it's current, then you show it's current. Date of the next installment of the regular periodic assessment that is due, and the amount. Again, next monthly or next quarterly. Itemized list of all assessments, special assessments, and other monies owed on the date of issuance to the association by the owner for the specific property. So again, if the unit is delinquent, okay, to the association, what do they owe in terms of assessments, attorney's fees, interest, late fees? Everything needs to be itemized and itemized on the certificate. Also, an itemized list of any additional assessments, special assessments, and other monies that are scheduled to become due for each day after the date of issuance for the effective period of the estoppel certificate. And in calculating these amounts that are scheduled to become due, you can assume that any delinquent amounts will remain delinquent through the effective period of the estoppel. And we'll talk about the effective period of the estoppel in 1 second. That depends on how it's issued. So what else goes on there? Whether there's any capital contribution fee, resale fee, transfer fee, or other fee. And if so, the type and amount of the fee. Whether, this is important, number 2, whether there's any open violation of a rule or regulation noticed previously to the owner of the property in the official record. So if the current owner is in violation of some declaration provision or the rules and the association has written to the owner about that, then that has to be noted in the estoppel. So in essence, so the new owner, after the sale closes or the transfer closes, can't say, well, I wasn't aware that I couldn't have a purple door, or I wasn't aware that I couldn't have this kind of screen enclosure, where the prior owner was notified of that. If you notify the prior owner of the violation now, and you tell the new owner that in the estoppel, then you can pursue the new owner because he or she's been put on notice of that existing violation. Otherwise, they can argue, hey, you know what? You were supposed to tell me and you didn't. Number 3, whether the rules and regulations or the governing documents applicable to this unit being transferred require the approval of the board for the transfer, and if so, whether the approval has been granted for that transfer. Number 4, whether there's a right of first refusal provided to the members of the association, and if so, whether or not the members or the association have exercised that right of first refusal. You see that in older documents in the transfer provision. Sometimes back in the day, it used to be, rather than straight approval, disapproval, there was a right of first refusal to match the sale. You still see it. So if there is a right, and you have to indicate whether or not it's been exercised. Okay. A list of the contact information for all other associations for which the owner is a member. So if you're a member of this association, but you're also a member of a master association, then you have to indicate that other association and the contact information for that other association. And finally, contact information for all insurance maintained by the association. Typically, that would be the association's insurance agent, name, and address. Now, the fee. We mentioned before there's a fee that you can charge for this. If the unit is not delinquent, then you can charge a fee up to $299. Again, if no delinquency as of the date it's being issued. If the unit is delinquent, then you can charge an additional fee not exceeding $179. If it's a rush, in other words, they want to close this transaction right away, and they need the estoppel certificate right away. So if they want it on an expedited basis, then you can charge an additional $119, and you can deliver the certificate within 3 business days, rather than the normal 10 business days. Resolution. In order to charge an estoppel fee, the authority to do so must be established by a written resolution adopted by the board or provided by a written management, bookkeeping, or maintenance contract. What about late delivery? If the association fails to deliver the estoppel certificate within 10 business days of receipt of the request, a fee cannot be charged for the preparation and delivery of the estoppel. So the penalty for not getting it out timely is you waive the fee to prepare it. If someone has multiple properties or they own multiple units, okay, you can charge like a bulk fee for that. and the fee is right there. If they have 25 or fewer parcels or fewer lots, fewer units, it's $896. If it's 26 to 50 units they own, $1,194. Again, if it's some kind of bulk sale. 51 to 100, the number is there, $1,791, and more than 100, close to 3,000, 2,985 for more than 100 units. The fee is such an odd number right now because it used to be an even number, but then every 5 years it's adjusted based on a consumer price index. So that adjusts the fee typically upwards because, as we all know, prices generally increase, don't decrease. So they adjust the fee every 5 years. Now, the effective period, I mentioned that when you issue it, the estoppel certificate, it has a certain effective period. If it's issued by hand delivery or email, then it has a 30-day effective period. If it's issued by regular mail, some people say snail mail, but if it's issued by regular mail, then it's effective for 35 days to take into account the mail time. Each amendment or correction to the certificate, if you have to amend it because there was a mistake or an error to add something to it, that creates a new effective period, whether 30 or 35 days, depending on how it's been issued. You cannot charge, though, for the amended estoppel. It does create another effective period, but you can't charge another estoppel fee. The association can charge for a new estoppel, even regarding the same transaction, if it is issued after the previous one expires. So if you issue one, the deal doesn't go through, doesn't close for some reason, no fault of the association, and then they ask for another one, same unit, you can then charge a new fee. Because that's not an amendment, that's a new certificate. Now, I'm just going to mention this before I go into this next topic. The key to remember with this estoppel certificate, if the unit is delinquent, let's say, and that is not properly disclosed, the new owner is not going to be liable for those unpaid assessments. So you got to be very careful that you're accurate with respect to that unit's, whether or not it's current or not current in the payment of assessments. Also, if there's a special assessment coming due, let's say in the next 10 or 15 days, which is within the effective period, and that's not disclosed, you're probably not going to be able to, you're not probably, but you're not going to be able to collect that from the new owner because it wasn't disclosed. So these monetary disclosures are very, very important, particularly with a unit that's delinquent, or particularly when you have a special assessment coming due shortly within the effective period. Must disclose these things, otherwise you've waived the ability to collect it. Okay, now Jeff, you can go on to the next. Okay, sometimes you're asked for other information though, particularly from banks, mortgagees, title companies, whoever, and they're asking for information above and beyond the estoppel. Okay, so what happens then? Well, the association or their agent, you can charge a fee. Okay, you're not required typically to respond to these requests, but I know a lot of associations do because they want to assist their owners in their transactions and their sales. So the association or their agent may charge a reasonable fee to the prospective purchaser, lien holder, which is i.e. the mortgagee, the current unit owner or member, for providing good faith responses to requests for information by on behalf of a prospective purchaser or lien holder. Again, other than what's required by law. Now that fee cannot exceed $150 plus reasonable cost of photocopying, and importantly, and any attorney's fees. So if they're asking you things that, quite frankly, are answers or issues that should go to your attorney for response, because they're really technical legal issues, you can have your attorney prepare the response or assist you in preparing the response, and then charge the fees incurred to the party that's requesting this information. And also, very, very important in the next bullet point, under the Condominium Act, the association and its authorized agent are not liable for providing this information in good faith pursuant to a written request if the person providing the information, estoppel, includes a written statement in substantially the following form. So basically you say, the responses herein are made in good faith and to the best of my ability as to their accuracy. So if someone's asking you for additional information above and beyond what's required to be in the estoppel, and you provide it, you must, or you basically should, include this language that's on the slide at the bottom in the italics, because that will protect you in case that information is, quite frankly, inaccurate. Now, it won't protect you from basically fraud, but it will protect you from providing information that's inaccurate. And you made a good faith effort to give accurate, but there were mistakes. Okay, next. What else things are involved with purchase and sales? Well, there's the condominium question and answer sheet. Every association has to have one. There's certain information on there. That must be updated annually and must be provided to the prospective purchaser. Also, the seller or the selling owner has a duty to provide buyers what's known as a notice of all the hidden defects. Interestingly, that's not the association's responsibility, okay, but it is the selling owner's responsibility to inform the buyer about construction defects and things like that. Also, the owner who is selling, okay, assuming it's not the developer, also has to provide at the selling owner's expense a copy of the following: declaration, the articles of incorporation, the bylaws, the rules, the frequently asked questions answer sheet, which we just mentioned. And the purchaser is also entitled to receive from the seller, the selling owner, a copy of something known as a governance form, which is provided by the division. I'm sure Alan probably mentioned the division, which is the Division of Florida Condominiums, Timeshares, and Mobile Homes. And that governance form summarizes certain topics regarding the operation and governance of condo associations. So what goes into that? What goes into this governance form that the owner is required to give to the buyer? Okay, just things such as the role of the board in conducting the day-to-day affairs of the association on behalf of and in the best interests of the owners. The board's responsibility to provide advance notice of board and membership meetings. The rights of owners to attend and speak at board meetings and membership meetings. And we're going to talk about that further on in my talk. The responsibility of the board and owners with respect to maintenance of the condominium property, and the responsibility of the board and the owners to abide by the condominium documents, Chapter 718, rules adopted by the division, and reasonable rules adopted by the board. Other items that this governance form also covers or addresses: the owner's right to inspect and copy association records, and what are the limits on those rights? And I know Alan talked about that in a fair amount of detail before me. Remedies available to owners with respect to actions by the board, which may be abusive or beyond the board's power and authority. The right of the board to hire a property management company, subject to its own primary responsibility for such management. So you can't just delegate everything to management, but boards definitely can rely and use management personnel, management companies, and property managers. The responsibility of owners with regards to payment of regular or special assessments, which are necessary for the operation of the property, and the potential consequences of not paying or failing to pay those assessments. The voting rights of owners and rights and obligations of the board to an enforcement of rules in the condominium documents and the rules adopted by the board. Now we're going to talk about some more of the enforcement mechanisms available to you when owners are in violation, including use right suspensions, voting right suspensions, and fining. Okay, fining. Ta-da! Everything but failing to pay monetary, because failing to pay monetary obligations is a separate part of the statute. And I can't recall whether Alan covered that in his part, but when you don't pay your assessments, there's a right to impose late charges if imposed by your documents, or not imposed, but authorized by your documents. But fining, we're talking about, non-monetary obligations. Okay. So other violations. The association has the authority to fine and suspend use rights of an owner or its tenant, occupant, guest, licensee, or invitee for failure to comply with the governing documents or association rules. That authority does not have to be in your governing documents. It used to be years ago. The authority to levy fines had to be in the documents. Now it's statutorily authorized. Now, importantly, or very importantly, a fine or use right suspension may not be levied, unless the board first levies the fine or the use right suspension and provides the owner with a written notice of the violation and an opportunity to attend a hearing on the alleged violation no sooner than 14 days from the date of the notice. So someone's in violation of whatever, okay, the board then imposes a fine on that on that owner. They also then have to basically send the owner a notice with a 14-day notice of an opportunity for a hearing for the committee. We're going to call it the fining committee. So even though the board imposes the fine initially, you have to go through this process in order for the fine to actually be effective. So that hearing must be held before an impartial committee of at least 3 individuals. The role of this committee is limited in determining whether to confirm or to reject the fine or use right suspension levied by the board. If the committee does not confirm the fine or suspension, it cannot be imposed. So the final say rests with this committee, okay, not with the board. The committee, if you want to make an analogy, is really like an appellate body, okay, in essence, where their role is to confirm, not to change, but to confirm or uphold or deny or reject the fine or suspension imposed by the board after they've held the hearing. So who's on this hearing? I mean, who's on this committee? All right. The impartial 3 members, at least 3 members, they cannot be officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. So that's the committee. And by the way, without the committee, there is no fining and there is no use right suspension. So I've had associations who, for whatever reason, can't find people willing or who want to serve on their committee. I'll call it the fining committee, but whatever name you want to give it, grievance committee, fining committee. Without the committee, though, then the association cannot impose the fine or the use right suspension because, again, that power does not rest solely with the board. Committee must approve it or deny it. Also, a fine, this is statutorily, by the way, in the Condominium Act, a fine may not exceed $100 per violation, and it may be levied, however, on the basis of a continuing violation with a single notice and an opportunity for hearing, but may not exceed $1,000 in the aggregate. Very importantly, though, a fine cannot become a lien against the unit, and it's due 5 days after the date of the committee meeting at which the fine was approved. I always say this as an editorial comment. It's not part of the outline, just from my own experience, that because of the inability to lien for it, it's not subject to your lien rights. In my opinion, it kind of takes a lot of steam out of the fine. Simply be aware that there is a monetary limit and there is a prohibition against liening the unit for an unpaid fine. What about use right suspension? Like I said, you can fine them $100, $1,000 in the aggregate for a continuing violation, or suspend their use rights. Okay, you can suspend use rights for the non-monetary violation. Okay, you can also suspend use rights if someone's delinquent. So through board action, this is without the you don't have to go through the committee when someone's delinquent. An association may suspend the right of an owner or its occupant, tenant, licensee, or invitee to use the common elements, common facilities, or any other association property if the owner is more than 90 days delinquent in any monetary obligation due to the association. However, in my experience, just as a practical matter, it's difficult to enforce these use right suspensions. It just is, because the police don't enforce them because they're civil matters. If you can deactivate a fob, that gives you some ability, but there are limits to what you can suspend the use of, and we'll talk about that in a second. In order for the use right to be suspended when someone is more than 90 days delinquent, the board must notice the owner, tenant, occupant, or licensee of the suspension after it's approved by the board. It's done in an open board meeting. Board meeting must be noticed. And that suspension is effective until the monetary obligation is paid in full. Now, a suspension applies to a member, and when appropriate, the owners or the members' tenants, guests, or invitees, even if delinquency or failure that resulted in a suspension arose from less than all of the multiple units or parcels that are owned by the members. So if they own 10 units, but they're in violation with respect to 1, you can still impose the suspension. While the association may suspend the right of an owner or its occupant, licensee, or invitee to use the common elements, common facilities, or the other association property, there is a limit, and here's the limit in red lettering there, or red font. The suspension does not apply to limited common elements intended to be used only by that unit, common elements needed to access the unit, utility services provided to the unit parking spaces, or elevators. So you can't suspend the right to those items. What about voting suspension? Okay, someone's delinquent and you want to suspend their right to vote. Well, there's a couple things about that. Again, through board action, so you don't need to go through the committee, but through board action, an association may suspend voting rights if the owner is more than 90 days delinquent in a monetary obligation due to the association. In order for the voting suspension to take effect, written notice of suspension must be mailed or hand-delivered to the owner, and if applicable, to the occupant, licensee, or invitee. The voting suspension is effective until the monetary obligation is paid in full. The delinquency, though, must be greater than $1,000, and proof of the obligation, the monetary obligation, must be provided to the owner 30 days before it takes effect. However, if you have an older set of documents, not that old actually, if you have a set of documents that came into being before the statute was amended to allow an association to suspend voting rights for someone being delinquent, then pursuant to our case, the Du Soleil South Beach Residential Condominium Association versus Du Soleil South Beach, the citation is on the screen there, that if you're in one of these declarations in existence before the statute was amended, then you either have to have what's known as Kaufman language, meaning that declaration provides it's subject to the Condominium Act as amended from time to time, or you have to amend the declaration to expressly allow the suspension of the voting rights. The reason for this is voting rights are a vested right, and in order to impair or affect that vested right, you can't do it retroactively, and therefore, if that document was in effect before the statute was changed, you need the Kaufman language, or you have to amend your declaration to expressly authorize the association to have that power to suspend voting rights for delinquencies.
Before we get to the next slide, Peter, here's have a water break real quick. I want to remind everybody two things. Ask any of your course-related questions into the Q&A module, not into the chat module. The chat module is for technical issues and where we're going to place the evaluation link a little bit later. In addition, a couple of you are asking, how do I get my questions answered? You might see me answering some. I'm only answering questions that we don't need an attorney to answer. I'm not one of the attorneys, so I can answer technical questions. What does this acronym mean? Simple things like that. At the end, Peter will get to as many as he can in the time that we have left. The important thing today in this 4-hour free session is to get you certified. The Q&A part is the bonus part. Okay, this is not something we have to do. But we do, we're going to get to as many as we can at the end. So just please keep that in mind as we try to get through this material in the time that we have. Peter, back to you, sir.
Okay. And as Jeff said, it's not that we're being difficult, although I've been accused of that, but it's not that we're being difficult with the question thing. It's just that this is a mandatory course. There's mandatory information we have to cover. And just because of the Zoom nature, it's sometimes difficult to stop and answer questions. So we'll try, like Jeff said, we'll try to get to them at the end. Okay. On the voting suspension, where it says, be careful what you wish for. If the association does suspend the voting rights of a particular unit, the voting interest allocated to that unit will not be counted towards the total number of voting interests for any purpose, including the establishment of a quorum and the votes needed to approve an action, whatever you're voting on, including elections, material alterations, amendments. So it's almost like the voting rights for that unit don't exist. And then you have to adjust for those units, if any, that you've suspended the voting rights for in terms of what is the quorum requirement and what is the voting requirement to approve things. Okay, now we're going to talk about another important topic. They're all important topics, but budgeting, reserves, and I know that Alan talked some about reserves in financial accounting. Okay, so every association, every fiscal year must have an annual budget. That must include the estimated revenues, operating costs, and reserves for the upcoming fiscal year, as well as the beginning and ending period for the fiscal year and the total assessments for each type of unit. Because obviously, as you know, I'm sure everybody listening, many associations, many, different unit types have different assessment levels. So in a condominium association, At a minimum, what must the budget address? Well, here's the list. This is taken also from the statute. I think it's 718-503 or 504, if I remember the exact number. But the costs are the administration costs, management fees. Not every association has management fees, but if you do, okay. Maintenance, rent for any recreational and other commonly used facilities. Again, if there's some kind of rec lease or long-term lease that the association is involved with. Taxes upon association property and any leased areas. Insurance, professional expenses, security provisions, other expenses that are applicable to the association, operating capital reserves, and paying the division the $4 per unit fee. I think it's still $4. Now, the annual budget is adopted by the board at a properly noticed board meeting open to all the owners. It is possible your documents could say owner approval, but that is exceedingly rare, okay? It's almost always a board function to adopt the budget. Now, the board has to provide the owner's 14-day written notice, either hand-delivered, mailed, or electronically transmitted to the owners, together with a copy of the proposed annual budget. So at least 14 days. And now, if your documents say 30 days, though, you have to do 30. Many older documents have a 30-day meeting requirement, 30-day notice requirement for budget meetings. So you do have to check out your bylaws or the declaration, both, to see if they have a longer period than the 14-day notice. The person providing the notice of the meeting must execute an affidavit evidencing compliance with that notice requirement or with these notice requirements to be kept among the official records. I know Alan mentioned some about affidavits. Here's another affidavit requirement that's very important. Now, during the actual board meeting, okay, the board is permitted to make changes to that proposed budget. I'm not saying you should double it, okay, but you are, permitted to make minor changes to it without sending out another notice of another budget meeting. A meeting of the board or the owners at which a proposed budget will be considered may be conducted by video conference, and Alan probably talked about video conference meetings, and the division must adopt rules governing the requirement for such meetings. Here's a new requirement. A sound transmitting device must be used. In other words, a microphone, sound transmitting device must be used so that the conversation of members may be heard by the board or committee members attending in person and by any owners present at the meeting. This next thing is new, this next bullet point. If a board proposes in any fiscal year, when I say new, as in new in this, the past session, if a board proposes in any fiscal year an annual budget which requires assessments against owners which exceed 115% of the assessments for the prior or the preceding fiscal year, then the board must simultaneously propose at the budget meeting before the adoption of that budget a substitute budget that does not include any discretionary expenditures that are not required to be in the budget. What are discretionary expenditures? Well, the statute doesn't address that, okay? So you're going to have to use your best judgment. But the things that are not included in the calculation of that 115%, so these are, these do not cause you to go over the 115%, would be reserves for the repair and the replacement of the condominium property, the structural integrity reserves, which I know Alan covered. Those are for condominiums that have buildings of 3 stories or more in height, and insurance premiums or insurance costs. So those items are not included in the calculation when you're trying to figure out whether or not you've exceeded the 115% limit. Don't ask me to do it because my math is terrible. So get someone better. Budget meetings. Okay. Owners must consider and may adopt. So if you do have a budget that's gone over the 115%, even taking out the excluded items, then prior to the board's adoption of the budget that exceeds that, you have to vote on, or you're supposed to vote on, the approval of the substitute budget. Approval of the substitute budget requires the affirmative approval of a majority of all the voting interests, unless your documents have a higher percentage that is required by your bylaws. So it's a majority of all, it's not just a majority of a quorum, it's a majority of all the voting interests. If the substitute budget is not adopted, then the annual budget that's been proposed, the one that went over the 115%, then that can be adopted. at least 14 days before a budget meeting in which a subsidy budget will be proposed, the board must hand deliver or mail to every owner a notice of the meeting. Again, if your documents have a longer period, then you have to comply with the longer notice requirement. Effective July 1st of 2021, so pretty recently, the board is required to adopt the annual budget at least 14 days prior to the start of your fiscal year. Don't assume the fiscal year is a January 1 through December 31st. Oftentimes, I mean, not often, but fairly often you'll see, June, July fiscal years. And some associations change their fiscal years because typically under the bylaws, the board can do that. So whatever the fiscal year is, that's the starting point, and that's when you have to comply with the 14-day requirement here. In the event the board fails to timely adopt the annual budget a second time, then it's deemed a minor violation by the division, and the prior year's budget continues in effect until the new budget is adopted. Reserves. I know you talked about reserves a lot, but we're going to do it a little more. Okay. So what are reserves? Well, reserves are for capital items or capital expenditures and deferred maintenance. So what are capital expenditures? Well, those are any expenditure or funds for the purchase or replacement of an asset whose life is greater than 1 year, or repair to an asset that will extend the useful life of the asset for a period of greater than 1 year. And assets can be all sorts of things: roofs, elevators, paving, insert that for the word asset. Deferred maintenance means any maintenance or repair that will be performed less frequently than yearly and will result in maintaining the useful life of the asset. So one is really replacement, think of it that way, and the other is deferred maintenance. Stuff that you don't do continuously on that item. Examples of capital expenditures and deferred maintenance include, for example, this is not an inclusive list: roof replacement, painting, pavement resurfacing, balcony restoration, sidewalk improvement, boardwalk replacement, seawall replacement, air conditioning equipment replacement. If money, again, these are just examples. If money is not set aside for these expenses, the owners will likely have to pay a special assessment or assessments at the time when the replacement or repair is needed. Now, you must include, and these are statutory reserves, and I know Alan talked about CEUs, I'm going to touch on it for a second, but the budget must include reserve accounts for capital expenditures and deferred maintenance, including, but not limited to, the roof, no matter what its costs, building painting, no matter what that costs, pavement resurfacing, no matter what that costs, and any other item that has a deferred maintenance expense or replacement cost that exceeds $25,000. For years, by the way, that was $10,000. That was the threshold amount, and now it's been raised to 25. And I know, not to repeat what Alan said, but if you have to do a SIR study, structural integrity reserve study, because you have buildings that are 3 or more stories in height, the roof and the painting is part of SIRs, okay, which is a special category of reserves. The pavement resurfacing, because it's not considered structural, it's still a statutory reserve, but it's not a structural integrity reserve item reserve. How do you compute the reserves? It's basically a formula, and I'm going to go through the formula pretty quickly here. Alan may have touched on this, but the amount to be reserved is computed by a formula based upon the estimated remaining useful life and estimated replacement or deferred maintenance expense of each item. The association can adjust the replacement reserve assessment annually to take into account any changes in estimates or extension of the useful life of a reserve that caused by deferred maintenance. So if you've done things, let's say to the paving, done things to the roof, that's going to extend the life of that, then the next year you can adjust your reserves to take into account that the estimated life, which maybe was 15 years, maybe now it's 20 because of some action that was taken. So you can adjust your reserve calculations accordingly. Funding for reserves must be based on a separate analysis of each of the required assets, again, or items, or a pooled analysis of 2 or more assets together in what's known as a pooled account. Unless the association maintains a pooled account of reserves, The reserve schedule should include each reserve account for capital expenditures and deferred maintenance or replacement as a separate line item with the following minimum disclosures: the total estimated useful life of the asset, the estimated remaining life of that item, of that asset, the estimated replacement cost or deferred maintenance expense of the asset, and the estimated fund balance at the beginning of the period for which the budget will be in effect, so the beginning of that fiscal year. But however, even for a pooled reserve account, where basically you're putting more, two or more items together in a pooled reserve, so any of the money in that pooled account can be used for any of those items. Even if you have a pooled reserve, the reserve schedule still must disclose the total estimated useful life, estimated remaining useful life, and estimated replacement or deferred maintenance expense for each asset that's in that pooled reserve account. What about waiving or reducing reserves? And this is only permitted for non-structural or, non-CEUs reserves. Also, going back to the pool for 1 second, and I'm sure Alan mentioned this, so I apologize for the repeat. You cannot pool non-structural reserve items with the CEUs items. You can pool CEUs items together, okay, but only those CEUs items can be in the pool. You cannot mix non-CEUs and CEUs together in a pool, in a reserve pool. Under the HB 913 statute, owner approval and other procedural requirements, funding for structural reserves can be paused for up to 2 years. What they did here is, and again, fairly recent change of the act, for those associations that are going through their milestone and their milestone inspections and milestone repairs, there is a methodology so that you don't have to both pay the structural integrity reserve contributions and pay for the milestones. You can actually pause for up to 2 years paying into the structural integrity reserves. Okay, doesn't mean that those go away. You still have to be calculating, but you don't have to actually collect them. So you can pause the collection for up to 2 years. Basically, this is to free up money to do the milestone repairs. And Alan may have covered this already. So there is this provision to allow this 2-year pause for funding the CEUs if you're doing milestone. The board adopts the budget with reserves fully funded unless the reserves are waived or reduced by approval of a majority of all the voting interests. Again, these are the non-CEUs reserves because you can't waive the funding of the CEUs reserves or reduce them except for the pause, which is not really reducing them, it's just pausing. This used to be a majority of the owners at a meeting at which a quorum was established, which quite frankly could be a much lesser vote, but it was increased now. If you're going to waive or reduce the funding of non-CEUs reserves, you need the approval of majority of all the voting interests of the members of the association. And it's only applicable for the budget year for which the vote is taken. So these votes to waive or to partial or reduce fund are only good for 1 fiscal year. And therefore, to keep waiving or keep partial funding, reduce funding, you have to do the vote every year. Whether to submit that vote to the membership to waive or partially fund is within the discretion of the board and is not required. So many associations do not give the owners, many boards do not give the owners the option to waive or to partially fund. They just budget and they fund fully funded reserves. And that's how they operate. Again, because you're not required to give the owners the ability or the option to waive or partially fund them. If you have a meeting and on the agenda is a vote on the waiver or the partial funding and you don't get a quorum or a quorum is not attained, then the fully funded reserves go into effect. Also, not on the slide here, you also have to be aware that under the law, under the Florida administrative rules, owners have to be provided a budget showing fully funded reserves, okay, and what they are before they vote to waive or partially fund them in order so they know what they're waiving. Okay, it's an informed vote. So they see the fully funded or fully funded reserves. So they know the impact of voting to waive or partially fund. So what can you use reserves for? Again, reserves are restricted funds. So pursuant to the Condominium Act, reserve funds and the interest accruing on the reserve account must remain in that account until spent on a designated purpose unless their use for other purposes is approved in advance by a majority of the voting interests. Again, all the voting interests. This also used to be a majority of a quorum. However, this is for the non-structural stuff. Excuse me. For the structural integrity reserve fund or study reserves, you cannot use those for other purposes. Can only be used. So the owners can't vote to use CERS funds for a non-CERS purpose. The closer you can get to it is by having a pooled account of CERS items in which the money in that pooled account can be used for any of the CERS items. It's not locked in for each one specifically. Pooled account. Non-structural reserve accounts may be pooled, and actually the structural ones can be pooled too, meaning that an association may have one reserve account to pay for multiple categories of reserves instead of separate accounts for each reserve item. If an association establishes a pooled reserve account for two or more reserve items, funds may be drawn from this account only to pay for any of the items in the pooled account. Used to be you had to get an owner vote to create these pools. The statute was changed and allows the board now to create pooled reserve accounts. But I know I've said this 10 times. I guess it'll be the 11th time. You cannot pool the non-structural and the structural together, though, or any non-structural items with the structural item. Limited proxies. We're going to talk about proxy voting a little bit further on, but just to know right now, if you're voting or if your members are voting on the waiver or the partial funding of the non-structural reserves, then the proxy, the limited proxy in which that vote is being taken, has to have this disclosure language. It has to be in bold, capital letters, the largest font on the proxy. And basically, I won't read the whole thing. It's basically telling the owners that waiving the reserves or partial funding the reserves means you're probably going to get hit with special assessments for those items. It's just like, hey guys, be aware, you vote in favor of this, you vote in favor of the waiver, in favor of the partial funding. I'm not politicking here either way. I'm just saying this is disclosure so owners are aware the impact of the vote. Financial reports. Okay, and financial reports, these, basically end of the year financial report, whether that's an audit, review, compilation. We'll get to that in a second. But every year you have to have an annual financial report. So within 90 days after the end of the fiscal year, or annually on a date that's otherwise provided by the bylaws, you must prepare and complete a financial report for the preceding fiscal year. The statute provides that the Condominium Act provides that within 21 days after the final financial report is completed by the association or received from the third party, meaning i.e. your accountant, but not later than 180 days after the end of the fiscal year. It used to be 120, it was increased to 180. You must mail or hand deliver to every owner a copy of the most recent financial report and a notice that a copy of the most recent financial report will be mailed or hand delivered to the unit owner without charge within 5 business days upon receipt of a written request. So you can either send them the actual financial report or send them a notice saying it's available upon request. If they make that request, then you have to provide it within 5 business days of their request. The association must provide an annual report to the Department of Business and Professional Regulation containing the names of all the financial institutions with which the association maintains accounts, and a copy of this report may be obtained from the department upon written request by any association member. Now, the levels of the reporting, we just mentioned that, touched on it briefly, but the level of reporting is based upon your annual revenues, okay? So if you have an annual revenue of 150,000 or more, but less than 300,000, the association is required to do a compilation. If you have total annual revenues of at least 300, but less than 500, then the report is a review, the reviewed financial statement. If your total annual revenues are 500,000 or more, then it's an audit, okay? An audited financial statement. If you have annual revenues of less than 150, it's only reported cash receipts and expenditures. However, I'll leave you notes on the slide. Notwithstanding what those revenue amounts are and those revenue levels are, if your bylaws or your declaration require an audit, then you have to do an audit, even though you might not reach the $500,000 audit amount. So you got to check out your documents and make sure that they aren't more restrictive than what the statute says. Can't be less, but they can be more. Now, the owners can vote for a reduced level. In other words, your owners can say, no, you know what? audit's very expensive. We'd rather have a compilation or a review or a report of cash receipts and expenditures. And then, with a membership vote, they can vote to reduce that, again, unless, documents somehow preclude that, but they can reduce that level of financial report, but you cannot do it for consecutive fiscal years. So if they do it in year A, year one, then they cannot do it in year two. Can't be done consecutively. The next topic, and we're going to talk about membership meetings, board meetings, insurance, and conflicts of interest. So, unit owner or membership meetings, okay? The one meeting that every association has to have as far as membership meeting goes is the annual meeting, okay? Annual meeting must be held at the location set forth in your bylaws. If the bylaws are silent as to location, then it must be held within 45 miles of the condominium property. Membership meetings may need to be held at a location accessible to a handicapped owner, or if someone requests that it be held in such an accessible place and they have a right to attend the meeting. The bylaws must provide the method of calling meetings of the owners, including your annual meeting. The regular election of directors must be held in connection with or in conjunction with the annual meeting. So the election and the annual meeting go together. What about other meetings of the membership? Well, those are special member meetings. Special member meetings refer to membership meetings other than the annual meeting. And when do you call those? Well, typically under most documents, they can be called by the board. Occasionally it says by the president or other officer, but usually documents say it's called by the board or upon the request of owners. It can be called upon the written request of at least 10% of all the other owners, of all the owners, unless a different percentage is set forth in your governing documents as far as owners petitioning or calling for a membership meeting. Now, these special membership meetings, there's various purposes. We were just talking about waiver of the reserves. That can be done in the special members meeting or in an annual meeting. Amending of documents, voting on material alterations. There aren't that many things that are subject to membership vote. So sometimes associations will call these special member meetings to vote on specific things, i.e. amendments to your documents or material alteration being two of the more common. Video conferencing, okay? Statute was recently amended to define what that is, okay? It's added to the Condominium Act to mean real-time audio and video-based meeting between two or more people in different locations using video-enabled and audio-enabled devices. Now, whether that's Zoom or other, Zoom is obviously the most well-known these days, but that's the video conference technology. The notice for any meeting that will be conducted by video conference must have a hyperlink and a call-in conference telephone number for owners to attend the meeting in that manner. There must also be a physical location where owners could attend the meeting in person. And I've been asked questions pretty recently, relatively frequently, can we have a Zoom-only meeting whereby there is no physical location, there is no place where people go to the meeting, they only attend the meeting or participate in the meeting either by conference, call, or video conference? And the answer is no, okay? There still must be a physical location for the meeting to allow those owners who wish to attend in person to do that. All meetings conducted by video conference must be recorded, and the recording must be maintained as part of the official records of the association. This is interesting. If an annual meeting, we just talked about annual meetings before, because the annual meeting is where the election is held, where your board election is held. If the annual meeting is conducted via video conference, then a quorum of the board must be physically present at the physical location where owners may attend the meeting in person. Physically present, not just present through video, okay? Physically present. So if your annual meeting is going to be video conferenced, then a quorum of the board has to be there in person. I'm not sure why this is in the law, but it is. If the meeting is conducted via video conference, it must also be recorded, again, part of the official records. Just important to remember, though, that if you're doing your annual meeting and you're doing it by video conference as well as in person, quorum of the board has to be in those seats in the room. Notice and agenda for these meetings. The written notice of a membership meeting must include an agenda and the meeting notice with the agenda must be mailed, hand-delivered, or electronically transmitted to every owner at least 14 days before the membership meeting, and conspicuously posted on the condominium property at least 14 days before the meeting. Again, check your bylaws. If they have a longer provision, comply with that. Posting. The board must, by adopted rule, designate a specific location on the condo property or association property at which all member meetings notices are posted. However, if there is no condominium property or association property upon which you can post notices, then that requirement doesn't apply. It's pretty rare. Mailing address. The notice must be mailed to every owner at the address last furnished to the association by the owner. However, if the unit is owned by more than one person, the association must provide notice to the address that the developer identifies for that purpose. And after that period, as one or more of the owners of that unit advise the association in writing, or if no address is given by the multiple owners of the unit, or they don't agree as to the address provided on the deed of record to that unit. And also, electronic transmission. You can only send notices by electronic transmission to those owners who have agreed in writing to receive notice in that manner, i.e., email or facsimile. The person providing the notice of a member meeting, an owner meeting, must provide an affidavit or U.S. postal certificate of mailing to be included in the official records evidencing compliance with the member meeting requirements. Again, these meeting notices also have to be posted as well as sent to the owners. Unless an owner waives in writing the right to receive notice of an annual meeting, the notice must be hand-delivered, mailed, or electronically transmitted to every owner. Unit owners may waive notice of specific meetings if allowed by your bylaws or the declaration or any applicable law. What about closed circuit television service? In lieu of, or in addition to physically, not the mailing, but the physical posting of the meeting notice, the association may, by rule, reasonable rule, adopt a procedure for conspicuously posting and repeatedly broadcasting the notice and the agenda on a closed circuit cable TV system for that association. The notice and the agenda must be broadcast in a manner and for a sufficient continuous length of time to allow an average reader to see the notice and read and understand the entire content of the notice and agenda. If broadcast notice is used in lieu of posting, the notice must be shown 4 times per hour for as many days as required for that notice. So if it's a 14-day notice requirement, then you have to do this broadcast notice for at least 14, for the entire 14 days. And by the way, what is an average reader? And I have no idea, but figure that one out. Notices and agendas, electronic transmission. I think I mentioned this already. I jumped the gun here a little bit, but associations may opt to deliver meeting notices by electronic transmission. You have to follow certain steps to do that, or adopt procedures that in your bylaws consistent with this. You can send those electronically to those owners who consent in writing, as I mentioned before, to receive official notice by electronic transmission. That written consent must be signed by the owner of record or by a person holding a power of attorney executed by the owner of record. Consent or revocation of consent may be delivered to the association by electronic transmission, hand delivery, mail, certified mail, or other commercial delivery service. And the owner bears the risk of ensuring delivery. What I mentioned here is if you or an owner agrees to receive their notices by electronic transmission, let's say email, which is obviously the most common, yet their computer, their malware or whatever, their antivirus stuff traps or otherwise throws the association meeting notices into spam, that's on the owner, not on the association. So as long as the association is using the correct email address that was given to them, the association is not responsible if the owner doesn't receive it because of glitches or problems with the owner's own software or hardware. Electronic notice cannot be used for the recall of a board member or for notice of a membership meeting at which the vote to forego retrofitting with the fire sprinkler system is to take place. Notice of a meeting is effective when sent by the association, regardless of when the notice is actually received by the owner, if directed to the correct email address or fax number to which the owner has consented. As I mentioned before, if you guys sent it out on time, and it take 3 weeks to get there because of some software issue, that's not the association's problem. An owner, as I mentioned before, an owner who consents to receiving notice by electronic transmission is solely responsible for removing or bypassing filters that block the receipt of mass emails sent to members on behalf of the association in the course. So that's what I just mentioned before. The association is required to maintain the email address and fax numbers of those owners who consent in writing to receiving notices electronically in that manner. If consent to receive notice by electronic transmission is provided, the email address and fax numbers are accessible to owners. Now, Alan talked about official records. Among official records that are normally not accessible to all the other owners are email addresses and phone numbers. But if an owner has given written consent to receive their meeting notices by electronic transmission, i.e. by email, then that owner's email address is accessible to other owners. It's no longer privileged or protected. So other email addresses, though, are, and you cannot provide those to owners. They're not accessible to owners. The only email address accessible to owners are those owners who have agreed in writing that that email address is their official address for receiving notices from the association. The association must ensure that the email addresses and the facsimile numbers are only used for the business operation of the association. An association cannot sell or share email addresses or facsimile numbers with outside third parties. If this information is included in documents that are released to outside third parties, the association must redact this information before the document is provided. However, the association is not liable for an inadvertent disclosure of an email address or a fax number unless the disclosure was made with a knowing or intentional disregard of the protected nature of the information. One thing that I want to mention here is a lot of associations enter into bulk cable TV and internet contracts. It's obviously very, very popular for very good reasons. In my reviewing a lot of these contracts, frequently or almost always, the cable company or internet providing company will request all the email addresses of all the owners in that community as part of the contract. And the reason they want this is pretty obvious, because they want to market their premium stuff, their premium channels, their premium services to the owners, and they want their email addresses. And I always fight about this, saying, no, we're not allowed to give a third party, and that provider, that company, that's a third party, to give them those email addresses. So this is just something to be aware of, that, again, the email addresses are not to be sold or not to be distributed to third parties. Now, for associations, now this says 150 or more units. The statute's been changed now. Actually, it's 25 units. I guess this is a older slide or whatever reason. But for associations managing condominium with 25 or more units, you must post a digital copy of member meeting notices and agendas in plain view on the front page of the website or on a separate subpage of the website labeled notices, which is conspicuously visible and linked from the front page at least 14 days before the meeting. You must also post on your website or an app, because you can have an app rather than a website, any document to be considered and voted on by the owners during the meeting, or any document listed on the agenda at least 7 days before the meeting at which the document or information within the document is going to be considered. Now, for an association managing condominium with less than 25 units, you may, in addition to any of the authorized means of providing notice of a members meeting, adopt a procedure to conspicuously post the meeting notice and agenda on a website, serving the association for at least the minimum period of time for which that notice is required to be physically posted. So, 14 days typically. And any rule adopted must minimally include a requirement that the association send to those owners whose email addresses are included in the association's official records an electronic notice in the same manner as a notice for a members meeting, including a hyperlink to the website where the notice is posted. What about your quorum and who's making the decisions for membership meetings? Well, unless a lower number is provided in the bylaws, the percentage of voting interest required to constitute a quorum at a unit owner meeting is a majority of the total voting interests. Unless your documents or the statutes provide otherwise, decisions to be made by the members must be made by a majority of the voting interests represented in a meeting at which a quorum is present. That means that the actual vote needed will depend upon how many owners are present in person or by proxy. And so the number of votes required is really a scale depending on, because it's the majority of those present in person or by proxy. But if your documents require, or the statute requires for a certain thing, X percentage of owners to approve, then it's X percentage of owners, not majority of a quorum. What about written consent? Written consent is a methodology where the owners can agree to something or vote on something by written consent in lieu of a membership meeting. Well, any approval by owners called for by the Condominium Act or by your documents may be taken by written consent in lieu of a meeting for matters for which action by written consent in lieu of a meeting is expressly allowed by the bylaws or the declaration or any law. I'm going to flip this around a little bit. Actually, what the statute really says is anything that needs to be approved by the owners or is subject to owner approval actually must be done at a meeting, voting in person or by proxy, and not by written consent, unless your documents expressly authorize the use of written consent or the statute expressly authorizes the use of written consent. Otherwise, do the vote at a meeting. How about the members' rights to show up and speak? Yep, they do, and you have to comply with this. So members have the right to speak at members' meetings with regard to all agenda items. The association may and probably should adopt reasonable rules regarding the frequency, duration, and manner of member statements. Recording. A member may record or video or videotape, actually video record, better phrase. A member may record or video record a meeting subject to reasonable rules adopted by the division. Only audio and video equipment that does not produce distracting sight or light emissions can be used. This was back in the days, because I've been doing this a long time. People used to come in with their almost like movie sets, and set up lights, and I'm not kidding, and big giant cameras. Nowadays, everyone uses they all use their phone. So that first bullet point generally doesn't really come to play anymore. Similarly, a second bullet point, if adopted in advance as a written rule, audio and video equipment must be assembled and placed in position in advance of the meeting. Again, because everyone these days just uses their phone, you don't really see that too much anymore. People coming in and setting up their equipment on tripods and things. If adopted in advance as a written rule, anyone videotaping or recording a meeting cannot be permitted to move about the meeting room in order to facilitate the meeting, in order to facilitate the recording. I've had this in meetings where they're roaming around the meeting, they're putting their camera, in everyone's face, including my face, and really disrupting the meeting. No, you can record, but you basically can't do it in a manner by moving around and basically just getting in the way and distracting the meeting business from being conducted. But you got to adopt the rule in advance to prohibit that. So I encourage you to do so. Also, if adopted as a rule in advance, you can require that advance notice be given to the board by any owner desiring to use any audio or video equipment. So if you want to make sure that people announce that they are recording, adopt a rule requiring people to state in advance that they are recording the meeting. Apologize for the drink. Okay, proxy voting. Unlike HOAs, this is not an HOA conference or a Zoom session, but in condos, basically you have to use a limited proxy to vote on any substantive issue. We'll talk about that in a second. You can use a general proxy, okay, to basically count towards a quorum. And a general proxy allows people to vote any way they see fit. But in condominium land and condominium law, any substantive matter, you have to use a limited proxy. So what is a limited proxy? A limited proxy is one where it lists the issue or issues to be voted on, okay, and allows the proxy holder to indicate directly on that proxy how his or her vote must be cast. In other words, it's directing the proxy holder. It's still a proxy, right? So I give my proxy to Betty Sue or Joe Blow, and they show up. But they're really just a warm body because they cannot use their judgment in voting my vote. I indicate on that proxy exactly how I'm voting or how I'm instructing them to vote on those issues. So a limited proxy, I always make this comment, it's kind of like the first cousin of an absentee ballot. In essence, because I am putting my vote on the face of that proxy before I give it to my proxy holder. Now you can use both to establish a quorum, limited proxies as well as general proxies. Unit owners cannot vote, as I mentioned, I think 3 times already, cannot vote by general proxy, meaning I'm allowing my proxy holder to vote however he or she wants, but may vote by limited proxy, and the form of that proxy must substantially conform with the form as adopted by the division. So what do you use limited proxies for? Like I said, really any substantive vote. If you're voting to waive or reduce reserves that we talked about before, if we're voting to waive the financial reporting requirements, which we also talked about before, if we're voting to amend your documents, if you're voting to approve a material alteration, okay, it's not on the list here, but that's another owner vote. Any other matter basically that the Condominium Act requires or permits the owners to vote on is done through a limited proxy vote, not a general proxy vote. Unless use of a limited proxy is required, a general proxy may be used in voting for non-substantive changes to items for which a limited proxy is required and given. Again, non-substantive changes. A limited or general proxy cannot be used in election voting. So, again, it's not part of my presentation, but when you're voting for the board, there's no proxy voting. That's all by ballots submitted by the owners. A proxy is effective only for the specific meeting for which it was originally given and any lawfully adjourned meetings thereof. However, in no event can a proxy be valid for a period longer than 90 days after the date of the first meeting for which it was given. But you can use this to your advantage, okay? So if you're calling a meeting and you're voting on amendments to your documents, for example, and let's say you need 2/3 vote of all the owners, because that's what your declaration says to amend. And you go to the meeting and you're short. You don't have that 2/3 vote because, you look at the proxies in advance and that's okay. You can, basically take a motion from the floor at that meeting to adjourn and reconvene the meeting at a set time later, or continuing the meeting to a set time and date later. And then the proxies are still good for 90 days. So that adjournment and not a final adjournment, but to adjourn and reconvene, that means, you can do that once, twice, who knows, 3 times within that 90-day period, because the proxies are still effective for 90 days. After 90 days, it's too late. Okay. So it is a mechanism, if you do it correctly, to basically gather additional votes rather than being short on the actual day or night of the meeting. Also, every proxy is revocable at any time at the pleasure, or maybe displeasure, of the member executing it. So I can revoke my proxy. Not after it's been counted already, but before that time. Now we're talking about membership meetings and membership voting and good stuff like that. And now we're going to talk about boards. Okay. The officer of directors have a fiduciary. I'm sure everyone's heard that word, to death. Officers of duties have a fiduciary responsibility to the owners and must act reasonably. Okay. But there is something known as the business judgment rule. And what is fiduciary? Fiduciary really means position of trust. Okay. And I'm not trying to poo-poo that. It is exceedingly important, but it just means that you're put in a position of trust with respect to that corporation and those members. But there is something known as the business judgment rule. What does that mean? That means that board members will not be personally liable. Okay, well, they're going to be sued, but they will not be, because anyone can be sued, but they will not be held personally and monetarily liable if they've just acted reasonably and in good faith. That's the business judgment rule. In other words, you don't always have to be, quote, right, unquote, whatever that is. But as long as you're acting reasonably and in good faith, this business judgment rule protects board members, with respect to their actions. But with respect to insurance, there was a specific provision in the Condominium Act. The board must exercise its best efforts to acquire or purchase insurance. They can rely on the guidance of experts, etc., but you do have to use what's known as best efforts when purchasing and acquiring insurance for the association property and for the association. Now, I'm sorry to tell you, you can't be paid. I know, very, very disappointing. But directors must not be compensated unless authorized in the bylaws, okay, unless it's for doing work in your trade for the association, in which case you have to comply with all the conflict of interest stuff, which we're going to talk about in a few minutes. So if you want to paint something for the association, yeah, you can get paid for that, but you got to jump through a lot of hoops because that's a conflict of interest because you're getting paid. The great power grab, ta-da. Anyway, unless otherwise provided, the corporate powers of the corporation are exercised through the board, okay? So therefore, for the most part, or almost all the part, the board is responsible for carrying out the association's duties and functions and responsibilities unless otherwise provided in the law or in your documents. Now, again, there are things that owners need to approve, but it's a relatively limited list. Now, interestingly, the second bullet point, which I've been dealing with for years, is no board member, not even the president, should make unilateral decisions. Every board member, okay, unless the power has been delegated to that person or there's an bona fide emergency, but every board member has an equal vote on that board, okay? The president, he or she, is not any more powerful in terms of making decisions for that association than any other board member. The board acts as a group through, again, I'm not saying all board members have to agree, and they probably shouldn't always agree, okay? Everyone has their own mind and exercises their own judgment. But no individual person, runs the show. Okay. The board is generally responsible for the maintenance of the association property and, with respect to maintaining the health, safety, and welfare powers, for the protection of the property and the owners. No free lunch. I think Milton Friedman came up with that, an economist. But basically, and this is, I'm sure everyone I'm talking to out there, this will never apply to you, okay, or hopefully not, but an officer, director, or manager, property manager, may not solicit, offer to accept, or accept a kickback, meaning anything or service of value for which consideration has not been provided for that officer's, director's, or manager's own benefit or that of his immediate family from any person providing, proposing to provide goods or services to the association. I hope this is pretty obvious. The association is hiring a painter. The painter can't paint your unit for free in order to get the work, or slide a bag of money under your door. Pretty obvious. Anyone, officer, director, or manager who knowingly solicits, offers to accept, or accepts a kickback commits a felony of the third degree and is subject to a civil penalty as well and must be removed from the office, and a vacancy is then declared. However, there is no prohibition against an officer, director, or manager from accepting services or items received in connection with trade fairs or education programs. I go to a lot of these shows. I'm sure you guys do too. So you pick up the swag and the stuff off the tables. That's not a kickback. An association and its officers, directors, employees, and agents may not use a debit card. This is interesting. Cannot use a debit card in the name of the association or bill directly to the association for the payment of any association expense. A person who uses a debit card issued in the name of the association or billed directly to the association for any expense that is not, quote, a lawful obligation of the association, unquote, which means an obligation that has been properly pre-approved by the board and is reflected in the meeting minutes or in the budget, commits theft and must be removed from the office and a vacancy declared. So beware of debit cards in the name of the association. Guilty until proven innocent, which sounds like the American way, right? Well, in this context, yes. A director or officer charged by information or indictment with any of the following crimes must be removed from office. Now, this is just charged. This is not convicted. Just charged or indicted for any of these things. Forgery of a ballot envelope or voting certificate used in a condominium election. Theft or embezzlement involving the association's funds or its property. Destruction of or the refusal to allow inspection or copying of an official record which is accessible to all owners within the time periods required in furtherance, not just not making accessible, but not making accessible in furtherance of any crime. And that constitutes tampering of physical evidence, obstruction of justice, or any criminal violation under the Condominium Act. So just being charged is enough to mean that you're off the board. So you're basically booted off, you're suspended, I guess a better word. You're suspended from the board if any of these charges are brought against you. The board then fills the vacancy until the end of the suspension period or end of the term, whichever occurs first, excuse me. If the charges are resolved without a finding of guilt, then the person, he or she, is reinstated for the remaining of his or her term. So again, this is a suspension, not a permanent, you're off the board. But you have to wait until the charges have been dismissed. A director officer who has just charges pending may not be appointed or elected to a position as a director officer of any association and may not have access to the official records of any association except under a court order or pursuant to a court order. Now, how to get off the board? Many of you just get on the board. Shouldn't be telling you how to get off. But there are several ways to go off the board. Resign in writing. And again, that's in writing. It has to be in writing. Recall, and that's a vote of the other owners. Delinquent in the payment of any monetary obligation. Again, that's any monetary obligation. Here, that would include a fine, okay, not just an assessment, due to the association for greater than 90 days. Now, if it's greater than 90 days, that means you abandon your office. So even if you come current on the 91st day, too late, okay? So this is not a curable thing. If you're delinquent in the payment of any monetary obligation for more than 90 days, you're off the board. It's an abandonment of office. Criminal charges, we just talked about those, involving theft or embezzlement of association funds. So that's just being charged, again, formally charged, not just someone pointing a finger at you at a board meeting. That means, indictment or arrest. For a knowing and willing violation of the Condominium Act, the division may order the removal of an officer or director, and they can levy fines, and failure to satisfy certification requirements. Then you're suspended. So, for example, taking this course, okay, if you don't get certified, then you're suspended until you are. Now, this is some new requirements for board meetings for a residential condominium association, which is more than 10 units. The board has to meet at least once every quarter. And at least 4 times every year, the meeting agenda must include an opportunity for members to ask questions of the board. It doesn't mean necessarily get to answer those questions, but at least 4 times a year, the agenda must include the ability of the owners to ask questions. Now, they can always ask questions anyway on any agenda item, by the way. That's because they have a right to speak, and we'll talk about that. Ratification. At times, the board may take action outside the context of a properly noticed board meeting and ratify at the next properly noticed meeting. So every now and then, we'll have a situation where the board takes an action, maybe it signs a contract or does something, and oops, didn't do it at an open board meeting. Well, you can ratify that action at the next meeting and ratify it, but I would not use this as a means of operation. In other words, this should not be, oh yeah, we're just going to ratify everything. We're going to do everything behind closed doors and just ratify it. No, this is meant to be something at time to time because of circumstances that come up, you can ratify. I do not recommend that it be done as your way of operating an association. What about email communication? You can use email as a means of communication among board members, but you cannot use email to cast a vote on any association matter. What about the notice requirements? For most board meetings, like I say, except for limited circumstances, certain circumstances, for most board meetings, adequate notice means posting conspicuously on the property, the meeting notice at least 48 hours in advance, except in a bona fide emergency. That 48-hour notice must include the date, time, and place of the board meeting, and it must have an agenda of what you're going to be addressing or what you're going to be considering at that board meeting. Now, when do you need more notice? Well, there's certain circumstances. Written notice of a board meeting at which a non-emergency, again, these terms are not to be tossed around lightly. Okay, most special assessments are non-emergency unless it's, bona fide like hurricane situation. But written notice of a board meeting at which a non-emergency special assessment or an amendment to rules regarding the use of a unit will be considered. Those meeting notices for those board meetings must be mailed, delivered, or electronically transmitted to all the owners and posted on the property conspicuously at least 14 days prior to the meeting. Okay. Evidence of compliance with this 14-day notice requirement must be made by an affidavit executed by the person providing the notice and filed among the official records of the association. Remember from several slides back, the budget meeting is another meeting. It's not a 48-hour notice. It's another 14-day minimum notice requirement. What about videoing? We talked about videoing before. Okay, a little more. Board meetings may also be conducted in person or by video conference. If the meeting is to be conducted by video conference, the notice must state that the meeting will be held via video conference and must include a hyperlink and a conference phone number for owners to attend, as well as a physical location where owners may attend in person. Again, if it's conducted by video conference, you have to record it, and the recording must be available as part of the official records, or must be maintained as part of the official records of the association. Remember, still have to have a physical location though. Can't just do purely remote. All right, posting, as far as posting notices. The board must, pursuant to a duly adopted rule, designate a location or locations on the condominium property at which all notices of board meetings must be posted. If for some reason there is no condominium property at which notices can be posted, then you must mail or deliver electronically transmit them to the owners at least 14 days prior to the meetings. We talked about closed circuit TV before with respect to member meetings. Well, with respect to board meetings, in lieu of, or in addition to the physical posting of a meeting notice, you can, by reasonable rule, or may, by reasonable rule, adopt a procedure for conspicuously posting and repeatedly broadcasting the notice and the agenda on a closed circuit cable television system serving the association. That notice, again, must be broadcast in a manner and for sufficient continuous length of time to allow Mr. Average Reader or Mrs. Average Reader to see the notice and read and understand the entire content of the notice and the agenda. And similar to the other for owner meetings, if you use broadcast notice in lieu of posting the notice, then it must be shown at least 4 times per hour for as many days as required for that notice to be posted. What about website? If you have an association of 25 or more units, you must post a digital copy of a board meeting notice, agendas, and any other document required for the meeting no later than the date required for the notice. In other words, if it's a 48-hour notice, it's got to be posted on the website 48 hours in advance. If it's a 14-day notice, because if it's a special assessment meeting, then you have to comply with the 14-day notice requirement for on the website. If you have less than 25 units, okay, you may, in addition to any other authorized means of providing notice of a meeting, adopt a procedure for conspicuously posting the notice and agenda on a website, serving the association for, again, at least a minimum period of time for which that notice is required to be posted. Any rule adopted must be, at a minimum, include a requirement that the association send to those owners whose email addresses are included in your official records an electronic notice in the same manner as a notice for a member meeting, including the hyperlink to the website where the notice is posted. All right, what about the agenda? Similar to what we talked about before, for member meetings, board meeting notices must specifically identify all agenda items. However, an item not included on the notice may be taken up on an emergency basis by a vote of at least a majority plus 1 of the board members. So what does that mean? Let's say you have a 7-member board, right? Majority is 4, okay? To take up an item on an emergency basis that's not on the posted agenda, it would require 5, or 4 plus 1, 5 of the board members to agree to bring it up on an emergency basis. However, that emergency action that was brought up in that way must be noticed and ratified at the next board meeting in order to be effective. Also, if 20% of the voting interests of the owners petition the board to address an item of business, the board, within 60 days after receipt of that petition, must place the item on the agenda at its next regular board meeting or at a special board meeting called for that purpose. Although I want to make this comment here, if a board receives this petition and the owners say, we want the board to put on the agenda, that you're going to, I don't know, plant impatiens rather than XYZ flower, and we want that on the agenda, fine. Then the board needs to place that item on agenda. It doesn't mean the board has to comply with the actual request, though. It just means the item has to be on the agenda for discussion and potential vote. It doesn't necessarily, that's not a petition to actually take an action. It's a petition to put an item on the agenda for discussion and consideration at a board meeting. If an agenda item relates to the approval of a contract, this is new and this is important. If an agenda item relates to the approval of a contract for goods or services, a copy of the contract must be provided with the notice and be made available for inspection and copying upon a written request from a unit owner, or made available on the association's website or through an application that can be downloaded. In other words, an app, download onto a mobile device. This language about the making the contract available with the notice of the meeting is a little problematic because it's not crystal clear in the statute. And I think personally, in order to ensure that you're in compliance with it, that means physically posting the contract that you're considering at a board meeting with the notice of the board meeting. I know it sounds cumbersome and maybe a bit crazy, especially for big contracts, but I just read it conservatively, and that's the way I read it. You can ask your own counsel for their own opinion, what he or she thinks, but that's my view on it. Last bullet point. Notice of any meeting at which regular or special assessments against the owners are to be considered must specifically state that assessments will be considered and provide the estimated cost and description of the purpose for such assessments. Well, regular assessments would be your budget meeting, and special assessments we just talked about, okay? So this is a bit superfluous in the act, in my opinion, but basically, budget meeting notice we talked about and how special they are, and you have to send out the notice along with a copy of the budget. Special assessment notices we just talked about too. And in a special assessment meeting notice, you have to indicate the estimated amount and you have to indicate the purposes of that special assessment. And that's a 14-day notice sent to the owners and posted 14 days in advance. Now, we talked about owners having a right to speak at membership meetings. So of course, they also have a right to speak at board meetings. Although back when I first started practicing 100 million years ago, there was no obligation or no authority for owners to speak at board meetings. So this is, like I say, this is new because I've been doing it a long time. Yeah, but interestingly, at one stage in my career, owners did not have the right to speak at board meetings. Anyway, but now they do. And meetings of the board at which a quorum of the board is present must be open to all owners, except meetings between the board and the associate's attorney, okay, with respect to proposed or pending litigation, if the meeting is held for the purpose of seeking or rendering legal advice. So if you're meeting with your counsel regarding pending or proposed litigation and you're getting advice about that matter, then that meeting can be closed and not open to the owners. Doesn't mean can't be that the notice requirement is no longer applicable, because it is. So you have to literally post closed meeting with the attorney to discuss, litigation. But the meeting itself is closed off because there's attorney-client privilege. The second closed meeting that you can have, or type of meeting that you can have, is when you're discussing personnel matters. And that can be anything: hiring, firing, disciplining, suspending of employees or management company employees. So those are the only two meetings where it could be a closed session without the owners in attendance or participating. Now, as far as all the other meetings, owners can tape, video, and audio the meeting, okay, record, subject to rules. It's really the same rules that applied we talked about before. As far as you can't have equipment that is distracting as far as lights or sound. If adopted in advance by rule, you can, require they set up their equipment in advance. And also, if adopted by a rule, you can require that anyone who's going to be recording audio or video or both has to basically announce that they're doing that, and you can't be allowed to walk around the room and be a pain in the blank and sticking their camera in everyone's face. An owner's right to attend meetings includes the right to speak. I said, years ago that wasn't, now it is, with reference to all designated agenda items. Okay, so all items that are on the agenda, and this is new, the second bullet point, the right to ask questions relating to reports on the status of construction of repair projects, the status of revenues and expenditures during the current fiscal year, and other issues affecting the condominium. So they have a right to question the board about those matters. However, we do encourage associations basically to adopt, because the statute allows you to adopt reasonable, and I will emphasize reasonable, rules governing the frequency, duration, and manner of member statements or comments during the meeting. What's a quorum? Okay, majority of the board present. What is present? We'll talk about that in a second. Right now, when any of the board or committee members meet by telephone conference or a video conference for that matter, those board or committee members attending by telephone conference may be counted toward obtaining a quorum and may vote by telephone. So before Zoom was around, we all used conference calls, okay, and speakerphones. And board members would be attending via conference speakerphone. They counted towards a quorum, and as long as we could hear them, when I say we, everyone in attendance, then they can also vote that way. A telephone speaker must be used so the conversation of those board members or committee members attending by telephone may be heard by the board or committee members attending in person, as well as any owners present at the meeting. So, long story short, if a board meeting is being held via conference call or otherwise remotely, bottom line is everyone has to be able to hear each other, including the owners in attendance at the meeting have to be able to hear the board members who are attending remotely, by conference call, whatever, and they have to be able to hear each other. Board members can appear and vote at board meetings not only via speakerphone, but also by video conference, as I mentioned, or similar real-time electronic or video communication, so long as everyone can hear. Now, unless otherwise provided by the Florida statutes or by the association's documents, the action of a majority of the directors present at a meeting at which a quorum has been attained constitutes the actions of the board. Occasionally, you'll see documents requiring a greater approval of the board for certain things. If that's the case, then you need greater than a majority of the quorum. Now, interestingly, or not interestingly, but importantly, directors may not vote by proxy or by secret ballot at board meetings, except you can vote by secret ballot when electing the officers, and that's it, okay? But there's no proxy voting, there's no, giving some other board member a slip of paper saying, this is my vote, or this is how I'm gonna vote. No, you have to actually be at that meeting. When I say be at the meeting, either in person or remotely, and vote that way. Only secret vote is on officers. A director who is present at a board meeting at which action on any corporate matter is taken is presumed to have assented to the action unless he or she votes against it or abstains from voting. A director who abstains from voting on any action taken on any corporate matter shall be presumed to have taken no position with regard to the action. And under the current law, it used to be you can only abstain for asserted conflict of interest. That was deleted. So now you can abstain for any reason you feel like, quite frankly. So you either have, if you're at a board meeting, either have to vote yes, no, or abstain, right? On the record. And a vote or abstention for each director present, again, in person or remotely, must be recorded in the minutes. This is important. You can't just put in the minutes that the motion passed 4-3, or that a motion failed 4-3, or 5-2, or whatever. You have to record in the minutes how every director voted on every issue, yes, no, or abstention. What about committee meetings? Okay, different than the board meetings, but a couple of things here that I think people are not really aware of. A meeting of a committee, which is authorized to take final action on behalf of the board, and that's pretty unusual, okay? Usually the committees are advisory and they don't have final authority to act. Or a committee that makes recommendations to the board regarding the budget are always required to meet like the board. In other words, they have to post notice, be open to the members allowed to speak, Okay, so they're subject to the same meeting notice requirements as board meetings, any committee that's authorized to take final action, again, kind of unusual, or any committee dealing with or making recommendations to the board about the budget. However, all the other committees also are required to post and hold their meetings like the board, unless they've been exempted by the bylaws. Okay, so whether it's a decorating committee, a maintenance committee, the social committee, the the all lawyers think committee, whatever the committee is. Okay, I mean, probably the all lawyers think committee is probably a popular committee, but the other committees must post their meetings and be open to the membership, okay, unless the bylaws exempt them, and in which case they don't have to be. The top two committees in the first bullet point, those are always posted and open to the members. They cannot be exempted. What about insurance? Everyone's favorite topic, right? Well, an association that's controlled by the owners as opposed to under developer control must use, and we mentioned this a while ago, its best efforts to obtain and maintain adequate insurance to protect the association property, the common elements, and the condominium property required to be insured by the association. So what is adequate insurance? Okay, basically adequate insurance, regardless of what your declaration says, is replacement cost. The adequate insurance is based on the replacement cost of the property, or may be based upon the replacement cost of the property to be insured as determined by an independent insurance appraisal or an update of the prior appraisal, and the replacement cost must be determined at least once every 36 months. I realize the statute says may, but the statute also says that the value is based upon an insurance appraisal that you obtain every 36 months or an update of the previous one every 36 months. So in my humble opinion, even though it says may, it's really a shall. It's really the insurance value or the adequate insurance coverage is replacement value based on that insurance appraisal. Now it is subject to reasonable deductibles, okay? But just think of it as, keep it simple. Insurable value, adequate insurance is the replacement cost based upon an insurance appraisal, and that appraisal must be done at least every 36 months. You can self-insure an association or group of associations. We don't have all the details here. It's very difficult. There's an entire statute about it. I've never seen it done because the requirements are so onerous or so difficult. So there is a possibility to self-insure, but and again, in my experience, I have never seen an association self-insure. You also should have insurance for your officers and directors, officer and director liability. I wouldn't serve on a board without it, and neither should you, quite frankly. So you need officer and director liability insurance for the benefit of your employees. You're not required to, okay, like medical insurance, things like that. But flood insurance is something that you probably should look into heavily. Even if you're not in a flood zone, it's not on the slide here. There's been a lot of research so I think it's a majority of flood damage happens to properties that are not in flood zones. So I would not ignore flood insurance. You have to get it through the federal government, but it's relatively inexpensive. Okay, fidelity coverage. This is basically to protect your money from being stolen, all right? So it's a fidelity bond, or it's also called dishonesty and crime insurance, but you must maintain adequate insurance or fidelity bonding of all persons who control or disperse funds of the association. Well, who is that? That term includes, without limitation, those individuals authorized to sign checks, as well as the president, secretary, and treasurer of the association. You also need to cover your manager and your management company, okay? That policy or that bond must cover the maximum funds that will be in the custody of the association or its management agent at any one time. And it's important because unfortunately, bad people do bad things, and I've seen it. I mean, it's not a lot, but I have seen it where the reserve funds disappear, someone disappears and takes the money. So it is important that the association be adequately covered with fidelity bond or fidelity insurance. That's a common expense as far as the cost of the bond, the cost of the insurance. And effective July of 24, if the division receives a complaint, the division will monitor the association for compliance with the statutory insurance requirements and may issue fines and penalties that they establish for failure to maintain adequate insurance or the insurance required under the bond. So again, it's hopefully something you'll never have to invoke, but you want to make sure, because one problem is, even though I said before that officer directors typically it's hard to sue them, and it's hard to find them monetary liable. A lot of D&O policies though have exclusions, and one of the exclusions is failure to properly insure. So if the property is not properly insured, or you don't have a fidelity bond and there's a loss, I mean, then directors and officers, in my opinion, are exposed. So it is important to make sure that the association is properly insured pursuant to the statute.
We're reaching the home stretch here. We're up to like the last 10 slides or so. So folks, if you haven't already done so, press the chat button so that the chat module appears on your screen, not to be confused with the Q&A where you're asking your course questions. Talking about the chat module, that's where we're going to place the required evaluation link. In fact, I'll do that shortly. Okay, we know it's a long day. You want to get out of here. So after Peter finishes the final slide in about 10 minutes or so, and then you click and fill out the evaluation. After that, you can go. The Q&A part is bonus. You don't have to stay for that. Peter, back to you.
Yeah, don't blame us for the marathon. We didn't make the law this way.
Exactly.
I know it's a long day for you guys. Hopefully it's somewhat informative. Anyway, okay. So we did fidelity. Next one, Jeff. All right. As far as the property required to insure, every property policy issued or renewed on or after January of 2009 for the purpose of insuring the condominium or protecting the condominium must provide primary coverage for all portions of the condominium property as originally installed or replacements of like kind and quality in accordance with the original plans and specifications, and any alterations or additions made to the condominium property or association property. And I'm going to cover this in a second, because what you insure and what you maintain or repair after a loss is different than normal maintenance and repair. It's a hugely important difference. On the next slide, I'll show you why. Okay. Because you have to read that in conjunction with this slide, which is the association, what it does not insure and what the owner insures. Okay, so basically the association insures everything that the owner does not insure. So what does the association, what's their coverage excluding? Well, it excludes personal property within the units, like the furniture and personal possessions within the unit or within the limited common elements, and the floor, wall, and ceiling coverings, like paint, wallpaper, etc. Electrical fixtures, appliances, water heaters, water filters, built-in cabinets and countertops, window treatments, including curtains, drapes, blinds, and hardware, and similar window treatment components, or replacements of any of those which are located within the boundaries of the unit and serve only that unit. Those are the things that the owner insures. The association basically insures everything else. Okay, so even things like windows and doors and the drywall, stuff that maybe you don't maintain and repair because it's part of the unit and the owner does it under your declaration. Well, in a casualty like a hurricane or a fire, unless the unit has been modified or changed from the original, the association insures those items. So the insurance and the maintenance and a loss is different than day-to-day maintenance and repair, not related to a casualty. In other words, not related to a hurricane or a fire or something like that, or a flood. Okay, owners are responsible for the cost of reconstruction of any portion of the condominium property for which the property insurance and the cost of any such construction done by association is chargeable to the owner. Now, there are some times where, and we're going to get to that in the next slide, where the owners are responsible for certain damages. Okay. Okay. Any portion of the condominium property that must be insured by the association against loss, which is damaged by an insurable event, must be reconstructed, repaired, or replaced as necessary as a common expense. As I mentioned before, unit, even drywall, interior doors, entry doors, things like that, unless they've been upgraded or changed, let's say by the owners, those things are insured by the association and replaced by the association, even though normally the association might not maintain them. However, an owner is responsible for the cost in addition to the things we mentioned before about things like appliances and built-in cabinets and that kind of stuff, wall coverings. Any portion of the condominium property which the owner is required to carry insurance, which I just mentioned, and any portion of the condominium property not paid by insurance proceeds if the damage is caused by the intentional conduct, negligence, or failure to comply with the terms of the declaration or the rules by an owner, the members of his family, occupants, tenants, guests, or invitees. So, for example, if an owner is doing, I don't know, making renovations in their unit and is negligent and, breaks a pipe with a sledgehammer, causes a flood, floods the other units, and even though the association insures all that drywall and stuff down there, if that damage was caused by an owner's negligence or his family member's negligence or their contractor's negligence, that owner then is responsible for that damage to the extent that it's not covered by insurance proceeds, like, for example, the deductible. So there are certain circumstances where an owner will be responsible for damage to portions of the property insured by the association, but it is limited. The cost of any such reconstruction work undertaken by the association is chargeable to the owner and enforceable as an assessment. So in that circumstance, if an owner did cause all that damage and there was a $10,000 deductible that had to be paid by the association, then that $10,000 can be assessed against that unit owner who negligently caused the damage. The association is not obligated to pay for any reconstruction or repair expenses due to property loss, to any improvements installed by a current or former owner of the unit or by the developer if the improvement only benefits that unit where it was installed and is not part of standard improvements installed by the developer on all the other units as part of the original construction. In the absence of an insurable event, the association or the owners are responsible for the reconstruction, repair, or replacement as determined by the maintenance provisions of the documents. Like I said, in everyday or ordinary wear and tear, let's say, for example, your documents govern the maintenance and repair. In the event of a casualty, though, you have to read the Condominium Act because, like I said, the maintenance and repair obligations are not the same as for what I would say ordinary non-casualty damage. Last topic is conflicts of interests. Directors and officers and the relatives of such directors and officers must disclose to the board any activity may reasonably be construed to be a conflict of interest. Okay, what is that? There's a rebuttable presumption of a conflict of interest under these circumstances. A director or officer or a relative of a director or officer signs a contract, enters a contract for goods and services with the association. So you're hiring the director or the manager, or the officer to paint the building. Okay, well, that's would be a conflict of interest because you're entering a contract with that director, with that officer to perform services. The other circumstance is that if that director, officer, or a relative has a financial interest in a company, a corporation, LLC, partnership, whatever, that conducts business with the association. So if you're hiring a pest control company and the director, has a partnership interest in that pest control company, then that's a conflict of interest. It has to be properly disclosed. If a director or officer or relative, again, of a director and officer proposes to engage in activity that is a conflict, then that activity must be listed and all contracts and transactional documents related to it attached to the agenda where the board's going to consider entering into that transaction, okay, on the meeting agenda. It requires to enter into that type of contract or transaction, it must be approved by a 2/3 vote of the other directors present, okay, not including the one who has the conflict. A director or an officer, again, the relative, whatever, who is a party to it or has an interest in it, that activity, it's a possible conflict, they can attend the meeting at which the activity is considered and is authorized to make a presentation to the board. So the director can stand up and give a spiel about why, the company should be hired or why he should be hired to do whatever it is. After that presentation, that director or officer or the relative, whatever, whoever it is that has the conflict there, must leave the meeting during the discussion of and the vote in the activity. So basically, after they give their spiel, they leave, the other directors discuss it, and they vote without that person being present. The attendance of a director and officer that has that possible conflict is sufficient to count toward a quorum and the vote in his or her absence. So remember, they're not there during the vote, but they do count toward a quorum for that meeting. A director or officer who is a party or has a party to or has an interest in the activity must recuse himself, as we mentioned, from the vote. If the board votes against it, so we're not going to do this activity, we're not going to do this contract, then that director or officer or that relative of the director and officer must notify the board in writing of their intent not to pursue it, not to pursue that proposed activity or to withdraw from office. If they withdraw, they withdraw. At the next regular or special meeting of the owners, the existence of the contract or transaction, let's say the contract was actually signed or it was approved, that contract, that transaction must be disclosed to the membership. And upon motion of any owner at that meeting, the contract may be canceled by a majority vote of the members of the owners present. If it's canceled by the membership, the association is only liable for the value of the goods and services up to that point, and is not liable for any liquidated damages or termination fees or any other kind of penalties. And if a board finds that an officer or director has violated this provision, in other words, didn't disclose that they had a financial interest in the pest control company or whatever, then that officer or director is deemed removed from office and there's a vacancy. So if they fail to disclose their interest, then that's a problem for that director or officer. A contract between an officer and a director and the association or their relative, again, that has not been properly disclosed as a conflict or a potential conflict is voidable. Right? It's voidable by the association. The contract terminates upon the filing of a written notice terminating the contract with the board, which contains the consent of at least 20% of the voting interests of the members, the owners of the association. An association managing condominium with 25 or more units must post in digital format on its website or its app, any contract or document regarding a conflict of interest or possible conflict of interest. So if you have any of these conflict of interest transactions or contracts, they must be posted. Quite frankly, folks, if you can avoid it, I would avoid the conflict of interest contracts or transactions unless you have some compelling interest to do it. If you do, then make sure you dot your I's and cross your T's in terms of the proper disclosure and vote. Finally, with managers, a community association manager or management firm, including their directors, officers, and persons with a financial interest in the firm, they also must disclose to the board any activity that may be construed to be a conflict. What's that? Rebuttable presumption of a conflict is if the manager or the management firm, again, including officers, directors, and persons with an interest or a relative, has a contract for goods and services, again, other than the management services. The management or the management firm, the other thing that could be a potential conflict is management or management firm, including persons, any of their relatives, have an interest or receive compensation from anything of value from a corporation or company that's doing business with the association. Similar, so it's really the same thing as we saw before, but now we're dealing with managers and management companies also not disclosing financial interests in companies that are contracting with the association. If the manager or the management firm, again, or their relatives proposes to engage in this activity, it must be shown and listed on all contracts relating to the activity, and it must be attached to the meeting agenda for the notice of the next board meeting. Those disclosures must be entered into the minutes of the meeting. Approval of those types of contracts require those, conflict of interest contracts or transactions also requires a 2/3 vote of all directors present. And at the next meeting of the membership, the existence of that conflict of interest matter must be disclosed to the members of the association. And if a manager or management firm has previously disclosed a contract, has disclosed a conflict of interest contract um, between the board and the manager of the management firm, that conflict does not have to be additionally noticed and voted on during the term of the management contract, but upon its renewal, it must be noticed and voted on again. So during the term of the contract, it's already been disclosed once, but if that contract gets renewed, then that conflict of interest matter must again be disclosed and approved. If the board finds out that the manager of the management firm, okay, basically has violated this section, then you can cancel the management contract with that manager or with that firm. If it's canceled, you're only liable again for the cost of the services up to that point and not for any fees, termination fees, or penalties or liquidated damages. And failure to disclose any conflict may constitute grounds for which disciplinary actions may be taken against the manager or the management company. I think that's at the end. Yep.
That is the end.
So I went 7 over, penalty on me.
Yeah,
So anyway,
we're in bonus time now.
Jeff, this is your turn to chit chat.
Yeah, we are in overtime here, and I know folks want to get out of here. So if you haven't already done so, I know Peter will handle a handful of very few questions here because we are past the time. So he'll go through them right now to answer a couple of them. But in the meantime, press the chat button if you haven't already done so. We're going to place the evaluation link in there for a fourth time in case any of you missed it. So there it is. And after you submit that evaluation, you don't have to stay. The required part is over. Again, the Q&A is bonus time. It's not something that's required, but it's something we like to do when we have the time to do it, which is also why we don't like doing these classes on demand, because then you don't have live people here to answer a question or two. So after Peter addresses a couple of questions, he's going to head out, and I will remain on to help you with any technical issues that you might be having with the evaluation. And then I'll share my screen and show you the process of filling out the evaluation and how to save your slides if you haven't figured it out for yourself. So, Peter, do you want to look at the Q&A section and take a couple, or do you want me to randomly pick a couple? You tell me.
Let me pull up the Q&A.
Okay.
Oh, Peter Cantor.
Just do a couple. I know we're over time.
This is all interesting information. How much of the compliance is the responsibility of the building management? Condo board is ultimately responsible. Okay. So you can't really delegate the responsibilities for compliance with your documents and the statutes to your board, to your management company. They assist you, but ultimately the board is going to be the one that's responsible. Regarding candidate, this is Bob. Regarding candidate eligibility for elections, if the association bylaws state that only a unit owner listed on the title can be a candidate in an election, do the bylaws take precedence? Well, yeah, I mean, you can limit, your documents can limit board member eligibility to being owners. Okay. You cannot not allow an owner unless the owner is disqualified because of delinquency or a felon or something like that. But yeah, you can limit that board members be members of the association. But if they don't limit that, if they don't limit it just to board member, just to owners, then anyone can literally run. So remember, the opposite is also true. If someone runs for the board, are they ineligible from running if they do not? I don't understand that question. I'm gonna go on. A lot of these look like they're milestone questions. I have 3 questions. Does the phase 2 mean repairs were completed and the inspection was passed? No, phase 2 of your milestone means these are repairs that you have to do. Okay. Phase 1 is to inspect the property for substantial structural deterioration. Phase 2 is then the actual details about what needs to be done to fix or repair the substantial structural deterioration.
Peter, just do 2 more because I know folks want to get out of here, and I got to still go over the evaluation process for those who are struggling with it, because I'm getting some text here that people are struggling with it.
Struggling with staying too long?
No, with the tech of the saving slides and things of that sort.
Let me find, I'll get some fine question.
You too, Greg. Good night. Have a good night. Thanks for attending.
When does the board have to vote as opposed to a president signing a 30? I think Alan did that. If a building is 4 stories, but each household has 2 stories, is the board still obligated to do a reserve study? And what else? Yes. Okay, it's the total height of the building. Just if you have multiple story units, they're included. You did not elaborate on, again, these are all Alan questions. You did not elaborate on how directors would be replaced in a recall. How would that occur? In a recall, if less than a majority of the board is recalled, the board appoints the replacements. If it's a majority or more, then the owners vote either through the agreement recall or at the recall meeting. I currently live in a community that has 5 HOAs and a recreation HOA. Who is the master? In that situation, it's probably going to be the recreation HOA, okay? That has overall authority over all the other 5 to a certain extent. What if one director approved the project without telling other board directors and owners? He should be taken out and beaten. Again, you try to avoid that, obviously. I mean, you need to have things, I mean, it goes into a lot of detail. Did he have a parent authority? Did he not have a parent authority? But like I said during my presentation, the board acts as a board and not through individuals. I'll take one more, I guess.
Yeah, do one more.
Here we go. Does a rewrite of the bylaws require an owner vote? Almost always. Occasionally you see bylaws that can be approved by, amendments to bylaws can be approved by board, but I would say 99% of bylaw amendments require some type of owner approval, and that would be set forth in the bylaws themselves.
Well done, sir. Thank you very much. Thanks for filling in, Peter. We appreciate the last minute super subbing. Thank you so much. And before you head out, the best way for folks to get in touch with you, Peter, is
call you. No. I am unlike Alan, who was smart to shorten his email address. I didn't even know that address. Mine is first initial P, then my last name, P Mollengarden at kbrlegal.com.
There it is in the chat. And folks, Peter's email address will also be on the slides, but I wanted him to speak a little bit more, because I know he loves when I make him do that. Yeah. So, Peter, have a wonderful.
For you all. Thanks, everybody.